Weekly list old matter, item number 1. Item number 1, sir. WA 21 of 2013.
None appears. Dismissal on prosecution.
Weekly list item number 2.
Your Lordship, I am in BC. I seek your Lordship's kind indulgence in the matter. Your Lordship, I have been instructed to appear in this case, but unfortunately, the advocate will be assisting me, Mr. Videsh Kumar Behra. He has undergone a surgery only last week. So
All
I
right. The request of counsel for
next
the
week.
Mr. Counsel, senior counsel, appellant. List on 21st November.
My lord, we are for the opposite party.
Weekly list item number 3.
My lords, item 3, I am appearing through video conferencing, my lords.
Yes, please.
This is a writ appeal which has been filed against an order dated 26/3/2013. My lords, the opposite party, my lords, had actually filed an application for staying. They had a due of roughly 23 crores against us, and they are a TV channel, my lords. We are a multi-service provider channel which gives the Star network channels as well as the Z network channels to the broadcasting channels in Orissa, my lords. So there was a sum of rupees 23 crores which was pending against us, and they moved an application before the.
But all this must be worked itself out. The interim order was for a limited period. There is no stay of that by this court.
Yes, your lordships. It was that I was just explaining the background of the dispute, and the order was in force till 30th April 2013. Thereafter, what has happened, I have no instructions. Maybe
That's all. You say the interim order itself was only for a limited period up to 30th April 2013. In the present writ appeal, no stay order was granted. Clearly, the impugned interim orders worked itself out. Consequently, the writ appeal is disposed of.
Yes, sir.
Weekly list item number 4.
Lordship, Lordship, I am sorry that item number 2, the interim order to continue.
All right.
Great.
Weekly list item number 4.
None appears. Dismissal on prosecution.
Weekly list item number 5.
My lord, I'm in VC, my lord. The matter has become infructuous as per my instructions.
All right. Counsel for the appellant states that the matter has become infructuous. Disposed of as such.
Weekly list item number 6.
Well, item number 6 on behalf of the conducting counsel, who is an accommodation, may be taken up 1 week after.
What is accommodation, sir?
So he has gone to attend the international conference of the tax lawyers at Dubai.
We'll just dismiss it. If it's important, he'll revive it. Since that tax lawyers conference is very important.
All international conference.
So we'll dismiss this. If this is very important, he'll come and revive it. As simple as that.
My lord, it was the fixed date. My lord may take, he is coming in the next week. So 1 week after, he will come and he will do.
He can revive it, sir. Whenever he comes from the tax conference, he can come and revive it. What is it about? What is the matter about, sir?
Order dated 8/9/13 and WPC 13/615.
It has not even come up once, sir. This appeal has not even been listed once in the last 9 years.
It was listed in 28/11/14.
What was the order passed on that date, sir?
No, it was only miscase was filed. No order passed.
That's what. This has never been listed even once. Never been listed even once in the last 9 years. Even today, the counsel, the appellant has apparently gone off for an international conference. And counsel appearing on his behalf is unable to assist the court. The appeal is accordingly dismissed with liberty to the appellant to have it revived. in case any cause of action survives.
Weekly list item number 7.
Here, this writ appeal in fact arises out of an order passed in a writ petition. The writ petition arose out of a order passed in a suit. As it is, the writ appeal may not be maintainable in view of the apex court judgment.
Yes, yes.
I withdraw this writ appeal with a liberty to approach the appropriate forum.
All right. Counsel for the appellant seeks leave to withdraw the writ appeal with liberty to approach the appropriate authority. Appropriate forum.
Yes.
All right. Disposed of is withdrawn with liberty straight forward.
All right.
Weekly list item number 8.
Please, I am appealing for the respondent, my lord. Kindly 1 week time, Mr. Rotho.
So suppose if we don't entertain this appeal at all, you still want us. Why do you just jump up? Let us first listen to the appellant, sir.
Sorry, ma'am. My lord, the petitioner challenging the order of honorable single judge at page 16, your lordship kindly see. Both petitioner, appellant and respondent number 4 was appointed a trained graduate teacher. The appellant was senior. Then respondent number 4.
Where is the order of the single judge?
Page 16, my lord. The question was, who is the in charge principal? The appellant being the senior claimed for in charge principal, but the honorable single judge, without considering the facts, dismissed the writ application at the stage of admission. May I read, permitted to read, my lord, the order?
Yes, yes.
The petitioner in this writ application challenged the action of opposite party number 2 in approving the services of opposite party number 2 as headmaster of the school with effect from 1/4/2008 in its letter dated 2/3/2009.
So you come to the court itself in 2012, 3 years, 4 years after the order is issued.
My lord,
you have come to the court with a writ petition of 2012.
My lord,
challenging an order of 2009.
My lord, thereafter, before that, I made a representation.
Can't we go on? So this is not like endless representation to be made.
Lordship, kindly see the order. What the honorable single judge held, my lord. Honorable single judge held that respondent number 4 has 7 years teaching experience, which is wrong, my lord. I am senior. How the honorable single judge held before appointment? My lord,
there is no stay of this order. This man has continued as headmaster since when? Since 2008.
My lord.
For 14 years.
Prior to, I also...
Come on, sir, please. No urgency is shown. Even for filing writ petition, no urgency is shown. When the writ appeal is filed, even for that, no urgency is shown.
I filed a miscase for staying of the operation.
But there is no stay.
Stay was
so there is no attempt to have the writ appeal heard early. Nothing.
My lord, stay was not granted.
Correct. So the fact of the matter is for 14 years that man has continued as headmaster now.
Lordship, kindly see second para of the impugned judgment.
Yes, yes.
It reveals from the annexure to approval order of the opposite party number 4 was trained graduate on 20th May 1991. His date of joining is 27/12/1997. After completion of 7 years as trained graduate teacher, the management of the school permitted him as a headmaster on 1/7/98. This is important, my lord. He was appointed in 97, but the date of a passing bid was taken into consideration.
No, sir. The 98 is actually 2008.
My lord.
After completion of 7 years as TGT, the management permitted him as headmaster not on 1/7, because he was appointed as headmaster. The first paragraph says he was appointed as headmaster on 2/3/2009 with effect from 1/4/2008.
He was both of us were appointed as trained graduate teacher, my lord.
No, correct, sir. But the date of headmaster is not 98, it's 2008. That first paragraph itself tells us.
His date of joining is 27/12/97.
Correct, sir. Now the next line, on completion of 7 years as TGT, the management permitted him as headmaster. No, it's something wrong here.
Therefore, I am praying, my lord.
No. The correct position is in the first paragraph, sir.
First, your lordship, kindly their approval order, our approval order.
It's an order of 2008. Not 1998, sir.
My lord, initially appointed in December 97.
As TGT, sir.
TGT, my lord.
We are now on headmaster. You are aggrieved by his being appointed headmaster.
No, in charge headmaster. No, regular, not regular headmaster.
Right. Okay, in charge. You are aggrieved by his being appointed in charge headmaster. You are more senior to him.
My lord.
Should be in charge.
My lord.
By now, regular headmaster must have been appointed
No,
for
no,
14
no,
years.
14
14 years only in charge.
respondent number 4 is still continuing, my lord.
I see. It's all right. All right. What is the ground? What are you challenging?
I'm challenging that that is appellant being senior, my lord.
How do you know you're senior?
My lord, my appointment is in November 97, 3rd November 97 at TGT. In the first selection, appellant was appointed. And the second selection, after 1.5 months, after 1.5 months, respondent 4 was selected and appointed.
All right. It's all about only in charge. No, nothing much tense on this.
Your lordship kindly see,
Yes.
in the case of Shivaji University,
Right.
Shivaji University Kolhapur
Yes.
versus Sangam Education Society, the apex court held that the senior most should be allowed to continue as in charge headmaster.
When did you become TGT?
In 3rd November 97, my lord.
No. That is your date of joining.
Date of joining, both joined as TGT, 10 graduate teacher, my lord. Both. He joined in December. I joined in the November 3rd. He joined in 27 December, my lord. And the honorable single judge held that he has completed 7 years. There is nothing wrong. He has not even completed 6 months, my lord.
No. What is the date of appointing as in charge headmaster? What is the date of appointing as in charge headmaster?
In Annexure 2, my lord. Page 12, my lord.
What's the date? You tell us, sir.
That is 27/11/2009.
So it's not 6 months, 7 months. You people joined in 97 as TGTs. The in charge headmaster is 12 years later, in 2009.
That is approval letter, my lord. Approval as TGT. Approval as TGT. My lord, what I humbly submit, being senior, I should not be ignored, my lord.
Anyways.
Your lordship kindly see the judgment of the Shivaji University and the honorable apex court.
It's all only in charge. It's not some regular appointment.
Only in charge, my lord.
Nothing to interfere in this, sir. The challenge before the learned single judge in the writ petition by the present appellant was to the appointment of opposite party number, appointment of respondent number 4 as in charge principal of the
Headmaster.
Dutial Model High School in Kendrapada district. Most of the claim of the present appellant was that he was senior to respond before and therefore should have been appointed as in charge. Paragraph. It is seen that the actual letter of appointment as in charge headmaster was issued on appointing respond before as in charge headmaster was issued on 2nd March 2009, making the appointment effective from 1st April 2008. Full stop. For some reason, the present appellant did not file the writ petition till 2012. That is a delay of more than 3 years. Full stop. There is no explanation offered for the delay. Paragraph. It appears that despite the delay, the writ petition was entertained by the learned single judge, who dismissed on the ground that the appellant did not possess the requisite qualification, that is 7 years as TGT, to be appointed as headmaster. This is contested by the learned counsel for the appellant, who says that the present appellant in fact joined earlier than opposite party number respond before as TGT. Paragraph. Be that as it may, the court finds that the opposite respond before is continued now as in charge headmaster for more than 14 years. And the challenge to his appointment itself was barred by delay and laches. Even in the present appeal, no interim order was granted. in his favor. Full stop. The court is therefore not inclined to interfere with the impugned order of the learned single judge. The appeal is dismissed.
Weekly list item number 9.
Relating to the same issue, your lordship is in session in other PILs also. That is congestion in Bhubaneswar city.
This PL was registered suo motu based on a news item regarding encroachments on the thoroughfare connecting Bhubaneswar railway station to the Cuttack Puri National Highway, bracket Buddha Nagar, bracket. With no substantive orders having been passed in the present suo motu writ petition and no pleadings also having been filed, the court is unable to proceed further in the matter. Also, due to passage of time, the ground situation would have changed. Consequently, the court does not propose to proceed further in the present petition and is disposed of as such.
Weekly list item number 10.
Then would be infructuous. It will be infructuous.
You have to speak louder, sir.
Well, it would be infructuous. This.
No, whom are you for?
Well, I'm for the state.
State. None appears for the petitioner, dismissal, not prosecution.
Weekly list item 11.
11 for, if I may please your lordship, my lord.
Yes.
My lord, it's my instructions that at present the reason why the letter was issued to this honorable court was for seeking some protection for the college students of Revansha.
That's all over now.
My lord, now it's inside the campus and it has become...
Due to passage of time, the petition has been rendered infructuous. It is disposed of as such.
Grateful, your lordship.
Weekly list item 12.
No instruction, my lord.
No instructions, disposed of.
Weekly list item 13.
Item 13, I presently have no instruction regarding the matter.
No instructions.
Kindly be permitted to withdraw the liberty to file.
No liberty at all. Right.
Hello.
Weekly list item 14.
14, my lord, no instruction.
No instructions, dismissed.
Weekly list item 15.
Dismissed. None appears.
Weekly list item 16.
16 minutes, the prayer, whatever you had made regarding the immersion procession of idols, the government
All
has already done.
infructuous, sir, now.
Yes, madam. Yes.
Counsel the
In
petitioner.
fact, madam, we sincerely
petition.
appreciate the government's step, madam.
All right. Rendered infructuous. Which disposed of as such.
Weekly list item 17.
16, my lord.
Disposed of as infructuous.
Item number 17.
Which matter are you there, sir?
My lord, I am appearing for the WPC number 611 of 2012.
For whom are you appearing, sir?
I am for appearing for workmen.
611 of 2012.
The 12.
No, it is one.
No. What we are calling out is 16330 of 2015. That is over. What we have now called out is 4529 of 2016. Maybe you're watching the wrong list.
Lordship, I'll check it.
Item 17.
None appears, dismissal, non-prosecution.
Weekly list item 18.
My lord, in this petition, the present petitioner challenging a limited pair that due to the Pichu mixture machine plant near the school, only 50 meters distance, polluted the environment for which
go to the NGT, sir, for the cause of for the grievance raised in the present petition. It will be open to the petitioner to approach the NGT for appropriate orders. Yes, the petition is disposed of.
Weekly list item 19.
Item 19, your lordship, no instruction, your lordship.
No instructions, dismissed.
Weekly list item 20.
May I please, your lordship? Lordship, may I be permitted to place the matter on behalf of Mr. Ramdas Sachal? My lord, this is a PIL wherein the illegal mining of minor minerals have been challenged. And the case was admitted, it was filed almost 6 years back. So my submission is the State Council may...
No order at all has been passed, sir. Not even notice has been issued in 6 years.
There is no order at all.
Not even notice has been issued in 6 years.
I'm sorry, my lord, I got...
That's the problem.
My lord, in
If
this
any
case,
cause of action survives, it will be open to the petitioners to first approach the authorities with appropriate representation. And after following up on such representation to seek appropriate remedies in accordance with law. The petition is disposed of.
Weekly list item 21.
None appears dismissed on prosecution.
Weekly list item 22.
22 minute not pressure.
Not pressed, dismissed.
Weekly list item 23.
None appears dismissed on prosecution.
Weekly list item 24.
24, my lord, infructuous, ma'am.
Infructuous, dismissed.
Weekly list item 25.
None appears dismissed on prosecution.
Weekly list item 26.
26 infructuous, ma'am.
Infructuous, dismissed.
Weekly list item 27.
May I please, Lord. My lord, the order dated 4/5/2018 may kindly see. The state was directed to take instruction as to my allegation.
What's the matter about, sir?
My lord, there was the headmaster of the school has misappropriated the amount.
You go to the Lokayukt, sir. For the grievance made in the present petition, it will be open to the petitioner to approach the Lokayukt in accordance with law.
My state was
Petition is
directed to
disposed
take
of. Yes.
Weekly list item 28.
May please, your lords. This is a PL relating to the Amruta Manohar properties of Lord Jagannath, which is being encroached by some influential people with the help of the government authorities. So by creating some false and forged documents. So as
Which people, sir?
Lordship?
Which people have created forged documents?
There are some government authorities.
No, which government authority?
So the authorities, land acquisitions authority, OE for the OE.
Are they all made parties, sir, to the petition?
Yes, Lordship.
No, nobody has.
Actually, Lordship, my only grievance is...
No, our only grievance is that people whom you are accusing should be made parties. That is our grievance.
Lordship, I have got some certain documents regarding this.
No. You should first make them parties. Without making them parties, without pleadings in support of such making them parties, we can't entertain such petitions.
Lordship, my only grievance is, as per the Supreme Court judgment, Apex Court judgment, in 2016, one OILA, Supreme Court 2009. So all the Jagannath temple properties should be protected. So this is one of the Amruta Manohar properties also been protected.
So we'll simply dispose of the petition, sir?
So Lordship, I may get 1 week time to file some documents.
Not necessary, sir. Since you have no grievance. You have any grievance in the petition?
Yes, Lordship, actually.
What is the grievance?
So I've got some orders of the authorities.
What is your grievance?
So my grievance is that the properties which has been encroached.
Who's encroaching?
Some influential people are encroaching this.
Which parties are they, sir? Opposite parties what? Please turn to the cause title.
The opposite party is the chief it is the secretary of the law department. And
he's encroaching.
No, they're not encroaching.
Kindly understand the question, please.
Yes.
Don't waste the time of the court like this.
Investigate the matter,
Sir, please tell us who is encroaching.
No, actually we are having this is the paper cutting. We are doing the
you have to do some investigation, preliminary investigation yourself. You have to find out who's encroaching. You have to make those people parties. You have to have pleadings in support of such making parties.
Sir,
we are not conducting a class on how to file PIL, please. These are very basic things which you yourself should know.
Yes, Lordship. Actually, my only prayer is that...
You said despite repeatedly telling the petitioner that if he has grievance against specific individuals who, according to him, have allegedly encroached on properties belonging to the temple of Lord Jagannath, he can file a petition only by making them parties. The counsel, the petitioner is unable to understand this very basic concept. Consequently, the court is not inclined to entertain this writ petition. It is dismissed.
Weekly list item 29.
None appears dismissed for non-prosecution.
Weekly list item number 30.
None appears dismissed for non-prosecution.
This is a public interest litigation filed by villagers. The land has been muted and under the OPL Act against the name of a headmaster working in a government school, my lord. Lease was showing him as a landless person. He has sold the land to his brother, my lord. We have made complaint before the collector. Collector has directed the Tahsildar to file appeal case in page 26, my lord.
Who's appearing for opposite parties?
For the private opposite party, I'm appearing. But without recording my statement, I don't also feel that it's a correct.
All of you are in 31.
31 item.
31.
31, na? 31.
Jayanta Kumar Khandayatra.
No.
Item 31.
Even before he called out the matter, you started arguing. So we thought you were arguing in 30.
4 and 5.
No.
Yes,
31.
I also thought that it is 30. So you were in 31. 30 was called, na?
Anyway, 31 has now been called. It's okay.
30 is disposed of, my lord.
30 nobody appears, that is why.
All right. Yes, what were you saying, Mr. Ratta?
Lord, in fact, the ADM has passed an order directing the authorities to file appeal against the settlement in my favor. Lord, without recording my statement, your lordship may also kindly see that I can't support this kind of settlements. Though it is in favor of my client, I can't support it. But then your lordship may not record it. Lordship may direct the authorities to act in terms of ADM's order. ADM has already passed an order.
Yes. It is seen that in the present case, the additional district magistrate has already passed an order, which is when?
That is at page 22.
26.
26, no?
26.
26. I am grateful. 26.
Has already passed an order on 5th April.
Case number?
5th September, sorry, 2014.
Godadhar Sahu.
Asking for action to be taken in LE case number 20 of 2002 on account of open petition, serious irregularity and violation of rules oblique guidelines. Unquote. Since no action appears to have been taken on the above letter of the ADM to the Tahsildar Khera, a direction is issued that the collector Baleshwar will immediately treat the representation at Annexure 1 as an appeal against the order passed in the aforementioned LE case number 20 of 2002. No, the sub-collector as an appeal against the order passed in LE case number 20 of 2022. And for this purpose, the matter will be placed before the sub-collector on 26 September 2022. The sub-collector is requested to proceed in the matter in accordance with law after notice to all the necessary parties, and after giving them a hearing to dispose of the said appeal by reasoned order within a period of 2 months thereafter. Stop till such time status quo be maintained as regards the property in question.
Well,
item number 32.
None appears dismissed, not prosecution.
Item number 33.
None appears dismissed, not prosecution.
Weekly list item 34.
May I please, in my personal capacity, my lord, I filed this writ application.
Defects not removed, sir.
My lord.
Defects not removed.
Lordship may give one time.
Defects be removed within a week, list thereafter.
Oblige, my lord.
Weekly list item 35.
35, my lordship. My lordship, it's filed against the authorities for not following the layout norms and ORERA norms during the subdivision plots registration. Only for plots.
This is again same.
No. Already getting notification is issued.
So are you aware that there are at least 4 petitions pending on the same issue before this court? Are you aware?
It's regarding the flats and duplexes. It's for subdivision of plots.
He means to say that is related to flats, etc. It is about vacant land, but the principle is same.
Whatever principle, how it's same.
Anyway, notice
layout
is different. That matter coming?
27 September.
Notice, he accepts notice on behalf of.
ORERA matter is different. This is the for the layout norms.
1 and 2. 4 and 5. Notice be issued to opposite party number 3 by registered speed post returnable on the next date. 27 September. Along with
WTC 18799 of 2020.
yeah 18799 of 2021.
Item number 36.
From 36 mile of public interest litigation, the petitioners are the villagers. The annexure 1 to the petition
Representation. Okay.
for the renovation of a tank miler.
All right. The petitioner's representation dated 26 July 2022 will be examined by the collector. Anugul, and after hearing the petitioners, and the reasoned order shall be passed thereon, not later than 28th November 2022. A copy of the decision be made available to the petitioners within a week thereafter. The court clarifies it as express no view on merits.
Weekly list item 37.
Item 37 is a PIL filed by the Odisha Association of Blind. It's a registered society. The prayer herein is simple for implementing the provision of section 33 and 34 of the Disability Act. It's for providing.
Give us specific instances where you want directions. This is too broad-based, the prayer.
My lord, state government till date has not earmarked. State government has till date not earmarked post for promotion.
So you say 1, 2, 3, 4, and then they can actually
maybe taken up. Then. My lord, maybe taken up next week. I will give you on affidavit.
States that he'll file an additional affidavit regarding the specific directions he is seeking in the present petition at his request list on 12th September.
Weekly list item number 38.
May I please, my lord? I'm on VC, my lord. This is a public interest litigation, my lord. The present petitions are the poor artisans, my lord, and they are supporting their livelihood by selling and making idols, my lord, in a different festival session, my lord. Recently, on 25th, my lord, the opposite party number 4, with some police official, enter into the workshop of the present petitioner in the afternoon and have a rob movement inside that workshop. And
my lord, I have obtained instruction. Your lordship may kindly have a glance over the instruction. What is the real fact?
No, my lord, they have not given anything on written, my lord, and the opposite party number 4 has obstructed.
My lord, there is a copy, report copy is there.
My lord, kindly glance annexure 1, page number 9, my lord. They are having objection upon these 2 idols, my lord. They are saying this is disfigured idols, my lord.
Okay, let him give him a copy of this.
My lord, another copy is there.
You can just share it with Mr.
Yes, I can share another copy of the report. That is the original one. This is the photograph. Yeah.
No. With the counsel for we have it.
I wanted to give it to him, but
Wapas. No, we have copies, sir. Mr. Mishra, there is a very detailed report of the police.
My lord. But my lord, kindly have a glance at Annexure 1, that is page number 9, my lord. These are the two idols. On that they are having
This is all, we can't go into the disputed questions, sir. They have a very different version.
My lord,
without reading their version, without knowing what they are saying, there's no point in your arguing.
My lord, they are misleading the court, my lord, because
you already know that. You already know that. You have not even read. You have not even read what we read now. You are already sure they're misleading.
No, my lord, because my lord, the present.
Sir, we have also been in the bar. We have also been in the bar when the opposite side shows a document to the court which contains details of the facts of the very case that we are arguing. As lawyers, we will not simply say, without even looking into the document, that whatever they are saying is false.
No,
I've never heard of arguments like this. I'm sorry to say. Without even looking at that document, without even knowing what is written in that document, you're straight away telling us it is false.
So, but I am on a virtual mode, my lord. This matter may be taken after launch, my lord. I have to take the copy, my lord. And I have to appear, my lord, in person, my lord.
Sir, these are going to be highly disputed because we can see from your tone and tenor, whatever they say, you're going to tell us. No, whatever they say, you're going to tell us it is false.
No, well, I'm sorry, because I have given that Annexure 1 that.
No. So according to you today, we should give a judgment saying whatever Mr. Mishra is showing us is 100% true. Whatever the government is showing us is 100% false. Therefore, repetition is allowed. Therefore, repetition is allowed.
I pray, my lord, this matter may be urgent to after launch,
my lord. I will WhatsApp the report to him. Let it come after 15 minutes even. It is only two pages.
Pass over.
Okay.
Kindly give me the number, please, Mr. Mishra.
Yes. 700851280.
Weekly list.
I may be pardon your lordship, item 23 for non-prosecution it has been discussed, but only my prayer is maximum number of the suggestions and my prayer has been complied by state government.
So if it's infractious, then we'll say it's infractious.
Only your lordship, I may be permitted to file a written note of submission by tomorrow. Your lordship may dispose.
No. Either you argue it today itself.
Yes.
Let's see whatever it is.
23.
The victims of lightning. I think we've already dealt with this.
No, that was your lordship. That was for rip current. Victims of rip current, drowning in the sea. Your lordship.
No. This is rip current. Even in this lighting thing, we had passed orders.
Already in lighting, yes, lordship has been pleased to pass order to file the affidavit regarding the non-payment of any compensatory amount. But what I have already directly visited these villages, and I have filed the memo, and I have got the information that the legal heirs of deceased who are victims of lightning, they have already received 99% persons are already received the compensation.
All right.
But only my prayer is regarding the suggestions what I have placed in my PIL. Let the only towards the awareness program, your lordship. Not.
We have stated in the affidavit filed earlier, my lord, may I please your lordship, that awareness programs are being taken widely through the mass media, papers, and that is being done. And we thank the petitioner's counsel for the suggestion, my lord. And she has also filed a memo saying that some persons have not received. We had conducted an inquiry. Personal inquiry was conducted by the Tahsilar, and we have given an affidavit also in 2022, my lords, that those persons where we were convinced that they have been injured or some amount of injury has been done, we have reimbursed. But where though no medical documents could be produced, there we have declined to.
Yes, that was the reason.
So we have filed an affidavit to
any medical document. That is why they couldn't get the compensation.
Where is that affidavit? Which affidavit?
That is on 20 we file it on, my lord. On 10th January 2022, my lords.
That's not here.
In response to their memo.
No, it's not here. You have another copy? You have a copy of the affidavit?
They have supplied the copy.
It's not here. 10th January.
10th January 2020.
It's not here.
Only my submission before I received that at page 11, I have given some suggestions regarding awareness program. They may take
They
steps.
say they're already conducting awareness.
In 2017-18, it was there. But recently, let's say my learned friend will also admit that the programs what they have taken up in 2017-18-19 after Corona period, there was no
Let them
such.
revive it already.
Only that.
The only
already
grievance of
part of
Mr. Karan Bala Rao Chaudhary, learned counsel appearing for the petitioner, is that there should be periodic awareness programs regarding lightning strikes amongst the general populace. Full stop. Counsel of the state submits that even earlier such awareness programs were being held, and she assures the court that similar programs on periodic basis would be conducted all over the state. Since no further directions are called for, the petition is disposed of. This place is on record. Right.
No placement.
All right.
Oh, bless.
Weekly list, press admission, item number 39.
May I please?
In this case, I have appeared so bottom. I have appeared so bottom. Copy not so.
Page 13 is the input order. First day disposal.
So motor it says. This is suo moto 39.
Also, I have appeared, but the case is admitted. First of all, I have filed the caveat, but the caveat period expired. Thereafter, I have shown.
No, I'm not able to understand. Item 39 is writ appeal 78 of 2021.
Yes,
correct?
I have appeared.
Huh?
I have appeared in this case, Miller.
No, you said suo moto.
Yes, but without this, with the matter has been
Suo moto, you're saying on your own you appeared.
Yes.
I see. All right.
Page 13, my lord, annexure 1. The dispute of at the admission stage.
So these matters have to go back, sir.
Yes, ma'am. Yes,
the writ petition in which the impugned order was passed was at the very first date of hearing. Was third only, no. The impugned order has been passed disposing of the writ petition on the very first date of its hearing without notice to the present appellants and giving them an opportunity of replying, giving a paravise reply to the writ petition. So on that short ground, the impugned order is set aside and writ petition civil 28831 of 2020 is restored to the file of the learned single judge, where it will be listed on 26 September 2022. The present appellant will appear on that day, as will the respondent, that is original writ petitioner. By that date, the present appellant would file a paravise reply to the writ petition, which will advance copy of which will be served on counsel for the writ petitioner. That is the present respondent. The learned single judge is requested to thereafter proceed in accordance with law and endeavor to dispose of the writ petition within 6 months. The petition is disposed of the above.
Weekly list, item number 40.
May I please?
What's the delay here? What is the earlier matter? Is any delay? No.
The delay during the COVID period.
So that earlier 39, if
this is also
the COVID period and therefore it's condoned. In this, again, same.
This is also during COVID period.
All right, same order in this also. And dispensing also allowed. Yes. Here also first date.
No, it is also dispute upon first day. In similar matters, your lordship has issued notice and fixed it to 28th October.
That is notice till the next date of hearing, the impugned order shall remain stayed. List on 28th October.
Weekly list, item 41.
That's item 41. The impugned order is against a direction to regularize contractual posts.
What's the delay here, sir?
My lord, 61 days delay Well, similar petitions are coming up on the 14th of September. My lords had adjourned it only last week on 24th. It's writ appeal number 777 of 2021. That is the lead matter.
What date? 14 September.
14 September, my lords.
List on 14 September along with writ
Writ appeal number 777 of 2021.
Yeah, 777 of 2021. All right.
Grateful. That stay may be granted. There's a stay application. There's stay application.
Notice will go on everything then, sir. Say notice on all of it's returnable. Right.
Grateful. Weekly list item 42.
Again, delays during Corona period.
Yes, ma'am.
All right. That's disposed of. That other. What's the writ appeal?
Well, impugned at Annex 2, page 111.
What's wrong with impugned orders?
Enter disputes, my lord. That man has retired on 31/12/2019. His next date of increment falls on 31/2020. The Honorable Single Judge has relying upon one judgment of Madras High Court has allowed that is not applicable to the case of the petition.
What is this man's age, sir, now?
He is 60 years.
No, he was 61 in when the writ petition was filed. What was his age?
At the age of 60 years. You also can find it from 111. His age is.
All right. Notice returnable. Okay. 17th October. Delays confirmed because Corona. Right.
Weekly list item 43.
That is relating to rehabilitation apartment application of 2020 rules. Honorable, that is a single day disposal.
So when are those matters? Because of that larger bench?
Yes, my lord. In your one case, your lordship has urgent that matter. Where the virus of that rule was under challenge.
Okay. All right.
At that Annex 1 to be stayed, my lord, they are filing a contempt.
Till the next further proceedings in the contempt petition are stayed. You have to say notice returnable, and then without notice we can't do it, sir.
Right.
Then you just take off that order. Then you just say notice returnable. 26th October till the next date, impugned order shall be stayed.
Weekly list item 44.
Item 44, my lord.
Defects have to be removed, sir.
My lord.
Defects have to be removed. Defects have to be removed.
My lord, within a week.
Defects be removed within a week. List there.
Weekly list item 45.
There is a delay petition also, my lord. There is no delay, most probably, because the
first cure the defects.
My
weekly list item 45.
With your lordship kind permission, item 45 and 46, both the matters, a coordinate bench, an appeal was preferred by at the instance of some private person where the state was also a party. State has also raised the contention, and that the judgment of the single judge has been upheld at the division bench in WA number 778 of 2021. Let's look to that judgment. So far the state appeal, this appeal is concerned, their lordship have dealt with that matter also at page 24. Page 24. As informed at the time of hearing, the respondent state has now filed writ appeals along with the application for condonation of delay to challenge the finding qua the...
Which paragraph are you reading, sir?
Sir, I'm reading at page 24 of the judgment. Division bench.
Yeah.
Subparagraph. As informed at the time of hearing, the respondent state has now filed writ appeals along with the application for condonation of delay to challenge the finding qua the non-applicability of the police order 2020 in the decision dated 9th September 2021 passed in the aforesaid writ petition. Learned counsel for the state submits that the entire process of selection was initiated as per the provision provided in the police order 2020, in as much as format of the question paper was as per the rules, although considerately the police order 2020 was published in the official gazette so and so. He further submit that the present selection, it was nowhere provided that 30 submit that in the present selection, it was nowhere provided 30 would be the pass mark, even as per the unamended provision, that is PMR 660. We are afraid that we are unable to accept the contention and hence reject it. It is an admitted case that till the enforcement of the police order 2020, the
No, according to this is covered by this judgment.
Yes.
You agree?
Yes.
All right. In view of the judgment dated 30th July 2022 of the division bench of this court, in writ appeal number 778 of 2021, the present appeal is also disposed of at the same terms. All right.
Both the 45 and 46 same.
Same. All right.
Weekly list item 47.
Dispensing with is allowed.
May I please? Let's turn to our next sort of fourth page 89.
Yes. This is fixing seniority in the basis of date of birth.
Well, what has happened, my lord? You'll also turn to that notification at page 55. This is the notification, this is the guideline for fixation of seniority of teachers of non-government for the purpose of appointment as principals of and HODs. Let's make find it from serial number 1. There are categories of lectures, category A, category B, C, D, E, and F.
Where are you reading, sir, again?
My lord, sorry.
Where are you reading?
I am page 55, my lord.
55.
55.
All right.
This is the notification which are the subject matter of challenge.
Correct.
35. 35 or
55. There are different categories of how the seniority to be fixed. But this category of people falls under category D.
Teachers in receipt of grant in aid in the shape of block grant.
Yes, my lord. But the entire notification has been quashed. The dispute relates to category D, my lord. But the entire notification has been quashed.
Your grievance is only to that extent, or you're also wanting to defend?
My lord, date of birth, I cannot defend on that.
But, okay.
But as my friend has, may I permit it?
Yes, yes.
As my friend has very fairly submitted that date of birth cannot be the ground. And so far the other grounds also, there are other cases also. It's a batch of cases.
No, in respect of that, only D.
No, the first case I was the counsel. There are other cases also challenging the same notification. Many cases were disposed of by the common judgment. And
no, does that relate to other categories?
No,
those
the
other petitions. Do they
other category, my lord, this will kindly turn to is what my friend was showing is this date of birth covers category C to F, page 57. Page 57. The date of birth concept applies to C to F. C means, my lord, the teacher receipt of grantee in shape of block grant from GI order 2004. D, teacher receiving grantee in shape of block grant under GI order 2008. Category E, teacher receipt of block grant in shape of grantee order 2009. F, teacher receipt of grantee in shape of block grant under GI order 2014. These are the four categories where they have stated in clause 3, Roman 3, 2, 3, page 57. For category C and F, inter-se seniority with respect to categories shall be determined based on the date of birth. So he has admitted that this is not, this is the correct view of the Honorable Court, and therefore it is not questioning. So now kindly listen to this A, B. C to F it has gone. Now A, B. A, B also there are cases, but I am holding the brief of the D. C to F. But these two categories also, there are other cases also where this is also not possible.
That has not
what
been
they have stated.
That has not been
That has not been
dealt in the judgment.
That has not been dealt with the judgment, but there are cases. That is my information. I am to submit.
But if those cases are not brought before the civil judge,
yes, many cases.
He may not have quashed the entire notification. That's the only point.
Yes, that there in this impugned judgment, there are many cases. In all cases, I was not there. The cases where I am there, these are covered by my friend's view. Date of birth was the seniority, and it is covered by the judgment. But the other category were also there.
I find from the judgment that is not.
The judgment, yes. I aspect of the matter.
Only date of birth has been dealt with.
But in another subsequent case, I filed one of such cases belonging to category B of that case. That was also allowed by the single judge, and that has been implemented by them. Kindly see what is category B. Kindly see category B. Yes, that has been you have implemented. That in case of Mahanga College, category B says the teacher in receipt of grantinate under J order 1994. These are the category B. And the category B is dealt with seniority 57. Within the category B, inter-se seniority shall be determined basing on the deemed date of joining as approved by the Higher Education Department or erstwhile Director of the Higher Education for the purpose of approval of release of grantinate. This point also in case of, my lord, I forget the name. I was the conducting counsel there. That has been allowed independently, bereft of all these things, and that was also implemented. Now he is
questioning this notification.
This notification was not challenged by interpreting this. Interpreting this clause.
In that case, he has said this notification is correct in respect of category A and B.
No, this was there. Originally, it was there. Originally, it was there. Deemed, virtually, category B says deemed date of joining. Deemed date of joining means, my lord, as I have understood, that is also government circular in that particular case. In way back in 1988, it says, my lord, an institution only can appoint a person in an institution after the subject was created in that institution. That is the concept. But all these institutions, before a recognition is granted to the institution, they appoint somebody. Suppose subject came in session 1988-89. So the session 88-89 starts with 1/6/1988. That is the law. So, but the person was allowed to continue in that institution in that particular subject in 87 or 86 prior to that. So they have used the word deemed date of joining means it will be irrespective of his entry into the service, any date prior to this 1/6/88, it will be count to 1/6/88 only. This past service will not be counted because this when there was no post where we were appointed. So that was the concept in that particular case where I was arguing.
May I bring my lord's notice 101, page 101, para 17. What was our ground before the honorable single judge?
No, I am not saying that it was not, but in other case. If you are challenging that order in the division bench, then that is all right.
So yes, Mr. Kuntia. What's your stand now? He says that other aspects of the other paragraphs are covered by other petitions.
I don't know, my lord. That has not. If your lordship will
I can
find
give
it
him
from
the numbers.
101,
I can give him the numbers and order also.
Then he'll have to file writ appeals against those also.
Yes. Yeah, otherwise,
you have also filed writ appeals.
No, implement korchhanti.
Who type of?
Move 8. That is JN college. College name is JN college.
He is saying that I am disputing that.
I will give you number and date.
I
can give.
I call this matter next week. I'll verify them.
All right. Counsel, Mr. Das, really learned counsel appearing for the opposite parties. States that he'll furnish Mr. Kuntia learned AGA for the appellant details of the other writ petitions where the directions issued by the learned single judge have actually been implemented.
So for category B is concerned, I am not concerned
Anyway,
about it.
we're not specifying which one.
Yes.
Give him the documents.
Yes.
At the request of Mr. Kuntia, list on. September.
Weekly list item 48.
May it please, Millards. Millards, I wish to appear, Millards, virtually, Millards. Am I audible, Millards?
Yes.
Millards, this is an application challenging the learned single judge's order, Millards, which is at page, Millards, 122, where, Millards, my writ petition, Millards, was dismissed. What was the, what did I pray for in the writ petition was a notification issued by the Orissa Medical Services Association, Millards, dated 28/6/2022 and 12/6/2022, whereby an election, Millards, of the Central Working Committee was being carried out, despite the fact that the election committee, which itself has been formed by the Central Executive Committee, which is functus officio already, because 2 years tenure is already over. Now, Millards, the tenure of the CEC, that is the Executive Committee, Millards, is 2 years as per the bylaws of this Orissa Medical Services Association, Millards. Now, Millards, before we proceed, Millards, this association is comprising of all...
is this issue still alive, sir?
Yes, Millards.
How?
Yes.
What's the term of this body?
2 years, Millards. Your Lordship will find that at page 36, Millards.
No. When was the committee appointed after the election? What is the date of the notification of the committee?
Which committee, Millards? The election committee.
No. Central Working Committee.
Central Working Committee, Millards. It is the election is being held for the for
Is this election already over or is it still to be held?
Today is a may I pardon, my lord. I'm sorry to interfere, my lord. Sorry to interfere, my lord.
Yes, sir.
Yes, Millards. The date, Millards, is the elections get over on 2nd of September 2020.
No, so they're already underway.
Yes, Millards, it has started.
But then request of court interfering, sir, once the election has started.
Today is voting, my lord.
Today it has started, Millards. My humble submission, Millards, is that the election process itself is illegal. In fact, Millards, I will not...
That you wait to challenge when the election results are announced.
No,
at
Millards,
that stage, you can challenge all this, sir.
No, Millards, may I just make one humble submission, Millards? The election, why it is illegal, another important aspect is the Constitution of OMSA itself says that 3 months time is to be given from the last date of nomination till the date of election. Millards, only 1 month. Only 1 month. Your Lordship will...
So now the law is settled. Once an election notification has been issued, the election process has started. The courts do not interfere. So if any losing candidate is aggrieved, he will raise the plea at that stage in a petition which he files challenging the election result.
No, Millards, I am not a losing candidate. I am one of the members of the association, and the association itself is illegally formed. I'm not sorry, Millards. The executive committee itself is functus officio completely since 2021. And any further actions that have been taken are completely illegal qua the constitution of OMSA. And that is why humble grievance, Millards. And Millards will see for a moment why this 30 days, Millards, is it is apparent on the face of it. Your Lordship may for a moment have page 42.
No, how is this? Is this the PIL?
No, my lords, this is, I am a member of,
No, so let's read the single judge's order then.
Please, my lords.
Let's read the single judge's order.
120, my lords.
Yes.
Starts at 122.
Yes.
In fact, there was earlier also one round of litigation where the writ petition was allowed, quashing the election notification. Thereafter, my lords, that's page 122, my lords. May I place, my lords?
Yes, yes.
So, Mr. Raut so advocate appears on behalf of the petitioner. He submits under challenge is inter alia notification dated 28 June 2022 issued by the Central Election Committee for election to posts of executives, Central Working Committee, OMSA. He relies on Constitution of OMSA, Clause 17. Milords will see there shall be a CWC consisting of all the directly elected members from the general body. There are state presidents, 3 zonal vice presidents, state general secretary, state treasurer, so and so. The tenure of the office bearers, Milords, this is important. The tenure of the office bearers / CWC members of the association is for 2 completed consecutive association years. He submits that tenure of 2 years of the CEC ended in year 2021. The said committee could not have appointed the Central Election Committee. It is only the general body who can elect the members to the Central Election Committee. Subclause E in clause 12 provides for the general body to elect office bearers of the association and members of such committee as have been specified in the Constitution. Central Election Committee is one such committee. He seeks interference. Mr. Naik, advocate appears on behalf of the opposite part number 5. He refers to order number such and such, Milords, passed in the earlier round of litigation. There should be direction upon the CEC to immediately constitute Central Election Committee for purpose of holding elections in the association. Mr. Naik submits such a direction be made. However, there is no submission made on behalf of the petitioner or state. He submits pursuant to direction inside said order, the elections have been notified. It was duly done. Petitioner is a troublemaker, does not want elections to be held. In any event, on commencement of the election process should not be interference. Mr. Sharma, an advocate, additional advocate, government advocate, appears on behalf of the state and subclause 5 under part 6 provides for procedures. Said clause says tenure of office bearers of the executives will be for a period of 2 years to be extended for not more than 30 years. On scrutiny of the impugned notification, it appears that Central Executive Committee in exercise of powers conferred under clause 29 in their resolution dated 8/8/21 communicated by 9/9/21 constituted the election committee, which following the said order dated 18th May of this honorable court, notified the election. On query from the court, parties have not been able to demonstrate from the Constitution the tenure of the CEC. Milords will see that tenure of the CEC is very much demonstrated in the Constitution itself, which says that it is for 2 years. So when the CEC itself is for 2 years, Milords, any steps taken by this CEC, which is functus officio already, that Milords itself is illegal. And why I say, Milords, may kindly for a moment have the bylaws, Milords. Your Lordships, the bylaws, Milords, starts at page 29, Milords. And your Lordship will see clause 30, page 36, clause 17.
Yes.
The last line, Milords, the tenure of the office bearers / CWC. So office bearers and CWC of the association is for 2 completed consecutive association years unless extended for a specific purpose for not more than 30 days by the CEC. Now, who forms the CEC, Milords? These office bearers form the CEC, which is, your Lordship, at page 36 itself, 15, clause 15, Milords. Sorry, Milords, clause 14. Your Lordship, may I have clause 14 for a moment? The Central Executive Committee shall be composed of the following members. Who are the members, Milords? State President, past.
Acharya, today the voting is underway.
Yes, Milords.
So let's not interfere with the process.
Milords, it is illegal.
You can raise all these pleas at the appropriate stage.
No, Milords, my humble submission, Milords, is this learned single judge has declined on the ground, not on the ground that the election process is going on, Milords. The learned single judge refused to interfere because the CEC is not defined to have any term, not defined to have any tenure, which is not a fact. The CEC definitely has a tenure because, Milords, the tenure of the office bearers of the CEC is 2 years. Now, if the office bearers do not, Milords, in fact, become functus officio in 2 years, Milords, where from the CEC will be constituted. That is the substratum of the case, Milords. And apart from that, Milords, another why I also seek indulgence of your lordships is that, Milords, hastily the election is being carried out. 3 months period is to be provided. It is being carried out in just 1 month. Milords will, for a moment, Milords will have page 119. Since your lordship is at the constitution, lordship may kindly have 42, page 42 for a moment, your lordship, please. Your lordship has page 42.
1 minute. Yes.
Milords, under clause B, filing of nomination.
Right.
Clause 6, while Roman 6, Milords, while issuing notice inviting nominations, the convener shall see an interval of at least 3 months being allowed between the last date of representation of the nomination papers and the date of election. Now, Milords, will see the last date of nomination is at 119. It is patent on the face of it, Milords. Therefore, I seek your lordships in a 119, Milords, please, for a moment, Milords. Lordship has 119.
1 minute. Yes.
Notification number 11, dated 11/7/22. Last date and time of withdrawal of nomination, Milords, is 22/7/2022. And Milords will see the date of election 29/8/2022. Today, Milords. And that is just 1 month and 7 days, Milords, which is absolutely in violation of clause 29B6 of the Constitution, which provides for 3 months. And this election is therefore being hastily carried out in complete violation of the Constitution itself. And therefore, Milords, I seek your lordship's indulgence, even if Milords, the election is underway. On the face of it, that election is illegal.
Yes.
Your lordship, turn page 47, clause 35.
Yes. But anyway, today is the first hearing.
Yes. Your lordship said there is a forum. Your lordship has clause 35. Your lordship see clause 35, page 47.
47.
Well, there is a forum. He can approach that instead of approaching my lords.
That's a internal mechanism.
Yes, my lords.
My humble submission before your lordships, my lord. The present appellant is not a candidate, my lord. And now he is not a contesting for the said election, my lord. He is only disputing the election process, my lord. And another point is that, my lord, the averments made by the appellant in the writ appeal, this is a disputed of facts. So it can be proved only by evidence by the my lord, election petition, my lord. And another is, my lord, now today is voting. Voting is going on, my lord, today. And another point is, I have also filed a decision, Honorable Supreme Court, that is year 2016, my lord, page 1094, para 14, my lord, 14, my lord, 14. My lord, in our opinion, the High Court was not right in interfering with the process of election, especially when the process of election had started upon the publication of the election program on 27 January 2011. And more particularly, when an alternative statutory remedy was available to respondent number 1 by way of referring the dispute to the central government as per provision of section 5 of the Act, read with regulation 20 of the regulation, so far as issue with regard to eligibility of respondent number 1 for contesting the election is concerned. Though prima facie it appears that respondent number 1 could contest the election, we do not propose to go into the said issue because, in our opinion, as per settled law, the High Court should not have interfered with the election after process of election had commenced. The judgments referred to herein above clearly show the settled position of law to effect that whenever the process of election starts, normally court should not interfere with the process of election for a simple reason that if the process of election is interfered with by the court, possibly no election would be completed without court's order. Very often, for frivolous reason, candidate or others approach the court, and by virtue of interim order passed by the court, the election is delayed or cancelled. And in such a case, the basic purpose of having election and getting an elected body to run the administration is frustrated. For the aforesaid reason, this court has taken in view that all disputes with regard to election should be dealt with only after completion of the election.
Yes, Mr. Acharya, I think that legal position is quite clear. This is a reiteration of what we've been saying, that once an election notification is on, and in your case, the polling itself is on today. At this stage, for the court to interfere will not be correct. On that legal proposition, we're not able to find anything wrong in what the single judge says.
May I just address this, Milords? Regarding the legal position, Milords, your lordship is right. There should not be interference. The interference is not called for at all. But Milords,
because you have a mechanism to challenge the election. You see, if you did not have a mechanism,
there's no mechanism, Milords.
No. There is a civil suit, if not anything else, sir.
No, Milords, here
we're not conducting free legal aid here.
No, Milords. Milords, I am thankful, your lordship. Now, Milords, what I'm submitting, Milords, is the election itself, by not giving that 3 months period, my rights are being scuttled today, Milords, and therefore I'm in a writ. My rights are being scuttled today, Milords. The requisite period is not given to me. And Milords, also, the other aspect that was pointed out, that there is the clause itself in the OMSA constitution, Milords, that it is only a conciliatory body which is not above the CEC. That's what clause 35 says. So, Milords, today, if the election process itself is illegal on the face of it, Milords, then, Milords, it cannot be allowed. I am sure, Milords, the facts of that case, whatever is being cited.
All illegalities are tested after the event when it comes to elections. As simple as that. That's the settled position which they've reiterated in various judgments.
Milords, that is not the ground on which the learned single judge has dismissed it.
No.
If the learned single judge has dismissed it on the ground only that the CEC doesn't have a defined tenure. That is not correct. CEC definitely has a defined tenure, which I have demonstrated before, your lordship. That's the ground.
Yes. You say the challenge in the represented appeal is to an order dated 22nd July 2022, passed by the learned single judge, dismissing the petitioners. Writ petition civil number 17104 of 2022. So the challenge in the said writ petition was to a notification dated 28 June 2022 of the Central Executive Committee. One minute. 28 June 2022 is by whom? Yeah, issued by the Central Election Committee, Orissa Medical Services Association, inviting applications from eligible candidates to contest the various posts of the Central Working Committee, CWC, of the OMSA. Also challenged before the single judge was no, just see, it was contended by the present appellant before the learned single judge that the time for filing of such nominations also was unduly shortened and contrary to the bylaws or rules?
Bylaws.
Bylaws, my lords.
Bylaws of OMSA.
Yes, UMSA constitution is what it is referred.
The learned single judge dismissed the writ petition on the ground that open quotation parties have not been able to demonstrate from the constitution tenure of the ACPs. Has also been shown to raise dispute regarding said resolution dated 8th August 2021 and communication dated 9th September 2021 made by the CEC. Unquote. It is submitted by Mr. Acharya, learned counsel for the appellant, that the learned single judge proceeded on an erroneous premise that the tenure of the CEC was not fixed, or that its constitution was not placed before the learned single judge. He says, in fact, he submits that in fact the CEC does have a fixed tenure. Paragraph. Be that as it may, the court finds that the polling process is already underway, and in fact today is the date of the polling. At this stage for the school, neither the single judge could have interfered, nor can this court entertain a challenge. The legal position in this regard is explained in a series of judgments of the Supreme Court, including Shaji K. Joseph versus V. Vishwanath, AR 2016 SC 1094. Paragraph. All grounds of challenge that the appellant may have can be reserved to be raised at the appropriate stage after the election is over, and the result is not, and the result is adverse, and the result thereof is required to be challenged by the present appellant. Full stop. Consequently, the court is unable to interfere with the impugned order of the learned single judge. The appeal is dismissed.
My lords,
before your lordship,
given to raise.
Yeah, that you just said. I've just said. Yes.
My lord, before your lordship takes criminal items, can you raise for item 38?
Yes.
My lord, may I please, my lord?
Is there?
Yes.
My lord, I have gone through this report, my lord. I have glanced at section 4, my lord. Actually, in this report, my lord, they have mixed up everything, my lord. The present petition is concerned with two idols, my lord. That is, they are saying 6-packed Lord Shiva face with matted hair having one imaginary bahana. Actually, my lord, these images or these statues are known as Rudra Ganesh, or otherwise it is known as Shiva Swarup Ganesh, my lord. My lord, there is says, my lord, everyone has two eyes, but no one has same view, my lord. The same thing has happened with the opposite party number 4, and he is having no exposure on the images of Lord Ganesha, my lord.
So you could have raised, this is not overnight, you could not have thought of these images. You know, there is a growing resentment. See, in the community, there is a growing resentment over these idols being made, correct?
Well, the present petition
31st is Ganesh Chaturthi and you want to come to the court on 29th.
Yes, mal. Because after
there is no time there.
And 26th I have filed, mal, and I have mentioned.
No, I'm saying it is not as if only on 26th you thought of these images.
No, my lord, this images was previously worshipped in Maharashtra. I have sent some photos to the mobile WhatsApp number of the government council and even also the mobile number.
All this can't, what I'm trying to tell you is all this can't be decided by the court.
No, my lord, because these two idols, my lord, I am concerned with these two idols, which I have annexed with my petition, my lord.
It's all right.
I have a glance, my lord. This is Shiva Swarup
So the assessment of what could be a resentment which can cause law and order is best left to the police to make.
My lord, they have not given me, my lord, they have not given me anything written, my lord. Neither they have issued any notices, my lord.
No, they have in the written instructions to the additional government advocate clearly said that. There's a lot of resentment in the local area. The local population is not in willing.
By showing red eye, my lord, they have taken some
para 8
from me.
They asked you to come to Purighat police station for a discussion.
And they have given an undertaking before the IIC Purighat that they will not sell this type of disfigured idols.
My lord, kindly have a glance to that pictures, my lord, that photos, my lord. What's wrong with this, my lord? This is the image of Lord Shiva, my lord.
That your lordship will visualize. I have given the images.
Yes. Even I have the color photos.
We are not restricting them to sell good idols with proper image of the Lord Ganesh. But these are not the way to promote your business.
They don't have any knowledge about Rudra Ganesh, my lord. Even we have convinced them, my lord, but they are not ready to listen.
And there is an image where the Ganesh is dancing like Pushpa cinema.
We are not. That Pushpa Ganesh has come from West Bengal, my lord, because they are the hereditary, my lord. They are the artisans of Cuttack town, my lord.
And there these are all
idols are coming from different sides, my lord, from to the state of Orissa, from out of Orissa, my lord. So I pray for these two idols, my lord, because I have invested my money, time, everything, my lord. It may be considered, I may be allowed to sell out, my lord, because the club people, they have already given advance, my lord, on 31st, and we could not make new idols for them, my lord. In consideration, my lord.
Yes.
And
you make other idols. You make other idols other than these idols and sell them.
They are making.
You can tell those clients also that you'll be giving them proper Ganesh idols. No problem.
Well, this is the proper Ganesh. This is Rudra Ganesh, my lord. Well, it is the devotee's eye, my lord, the one which way he will see the Lord, my lord.
Yes.
So the police is having no role, my lord, to intervene in the rituals and the culture.
Police has role.
And it's not easy for the police to handle all of this.
And they have to consider, my lord, just to allow me to ship that, to transport that goddess idol to the puja pandal, my lord. Because on that way, after hardly 48 hours, the puja is there, man.
All right. The present petition has been filed by two persons. Present petition has been filed by a person who is a resident of Silpi Kumhara Sahi in Cuttack, aggrieved by the actions of the inspector in charge, IIC Purighat Police Station, Cuttack, in preventing the petitioner from proceeding with the construction and sale of certain idols of Lord Ganesha for the ensuing Ganesh Chaturthi festival on 31st August 2022. Full stop. Photographs of some of the idols made by the petitioner, of two such idols made by the petitioner, are enclosed with the petition paragraph. An advance copy of the petition was served on learned additional government advocate (AGA) Mr. D.K. Manthi, who has obtained written instructions dated 28th August 2022 of the Deputy Commissioner of Police (DYCP) Cuttack, a copy whereof has been provided to Mr. Ashish Mishra and counsel for the petitioner as well as the court. Full stop. The explanation offered by the police is that on 25th August 2022, around noon time, they received information from the public and media people about the idols being made by the petitioner. Open quotation, of Lord Ganesh on their own imagination by disfiguring the sacred image of Lord Ganesh which hurts the religious sentiment of the devotee. Unquote. Apparently, the photographs and video footages of the said idols made by the petitioner became viral, and the police apprehended that it may lead to untoward incidents. Full stop. In the written note placed before the court, it is mentioned inter alia that the police asked the sculptors to come to the Puri Ghat PS for a discussion, and the petitioner and two others did appear, and they were conveyed that there is discontentment among the public, open petition, regarding such disfiguration of the idol of Lord Ganesh, which may create law and order situation in the area, and advised them not to make such disfigured idol of Lord Ganesh for the sake of respect to Hindu lords. Unquote. Paragraph. Mr. Mishra, learned counsel appearing for the appellant, petitioner, vehemently contests the above depiction of the idols made by the petitioner as disfigurement of the idol of Lord Ganesh, and seeks to justify the petitioner's right to persist in making such idols and selling them to customers.
It is already made, Malad. It is already there in your workshop.
Yeah, full stop. However, the situation that the police faces is one of law and order as a result of such idols being displayed in public. Full stop. Clearly, there is an alternative to the petitioner to make other idols of Lord Ganesh which do not create any resentment in the local public and do not create an occasion for any law and order situation which may go out of hand.
All right, but at least that's why we want to put number 3 to review my
In matters of this nature,
no,
where there is a genuine apprehension of untoward incident being created, which will lead to a law and order situation, the court would not like to sit in judgment over the assessment of the police. Full stop. Consequently, the court is not inclined to.
May I submit one thing? Lordship may observe that nobody can be allowed to create such type of disfigured idol of.
No, we don't want to get into all that. We don't want to get into all that.
It's okay.
We don't want to get into all that.
But your Lordship may kindly note the IIC Puri Ghat place is present with
the matter.
Your Lordship may kindly
issue the directions as prayed for by the petitioner.
My recommendation is pending before the opposite part number 3 Malad. It's the DCP Malad. At least he should review Malad. Kindly in the evening Malad, because I have invested a lot of money.
All right.
My Lord, may kindly note that the IIC Puri Ghat place has personally present and presented the note.
All
right. By considering my situations, it may be considered Malad kind of given the direction to the opposite part number 3 Malad, the DCP Malad. At least this DCP should go into it Malad, and he should look into it Malad. Whether it's a figure or disfigure Malad. It's the unnecessary they are creating such type of allegations Malad, which is totally baseless Malad. So direction may be given to the opposite party number 3 Malad. I humbly pray Malad. I humbly pray my recommendation is pending before the opposite party number 3 Malad. By today evening Malad. So we can Malad kindly consider my deprived condition Malad. Since last 2 years we are having no work Malad. We are sitting ideally Malad. And this is the first year this festival is going on Malad. And we are going to sell some idols Malad. So we are in a deprived condition Malad. So Malad kind of consider my deprived condition Malad. At least Malad direction to the opinion number 3 Malad. To consider my
orders item number 49.
Yes.
Weekly list for orders item number 49.
49, may I please, Your Lordship?
Yes.
Well, this is a leave to appeal, my lord. It is an order of acquittal by the learned Addison Session Judge Talcher, my lord. Well, here the sole appellant stood trial under section 449 IPC and 302 IPC. As the Lordship knows, section 449 is house trespass with an intention to commit murder, my lord. My lord, here, after going through the entire evidence and appreciating the evidence, the trial court has convicted him of 449. under section 449, but has acquitted him under section 302 IPC, my lord. My lord, my humble submission is that PW6 is the husband of the deceased. He is an immediate post-occurrence witness. This has happened, my lord. The occurrence is that in the middle of the night, around 12 a.m., this accused person with an axe has entered the house. He has given a severe axe blow on the, which of course the PW6 has not seen. Hearing the shout of his wife, when he has come, he sees the accused running away from the place holding an axe. What has been accepted by the court below? The learned court below has accepted, my lord. If I take your lordship to the last judgment, para 40, my lord, it's very explicit and very clear. Because PW6 is the husband, he has clearly stated the motive here. May I read that para 40, my lords?
Yes.
As regard to the offense under section 449 IPC, the evidence of PW6, the husband, my lord, remain uncontroverted that he has seen the accused Girish Bhoi inside the house being armed with an axe in the occurrence night. This part of evidence of PW6 was also not demolished during cross-examination and also gets corroboration from the FIR. As already discussed, accused has a motive to commit murder of the deceased Sasi Bhoi. So it can be presumed that accused has entered inside the house of the informant being armed with an axe in order to commit murder of Sasi Bhoi. The intention of a person can be gathered from different circumstances. When in the night, accused was armed with an axe and has entered inside the house of the deceased, and accused has earlier threatened the deceased to commit her murder. So it can be presumed that accused Girish Bhoi has entered inside the house of deceased Sasi Bhoi in order to commit a murder. Even if the offense of murder was not completed, but that no way affect the applicability of section 449 of IPC, when accused has entered in order to commit the offense, from my above reasoning, I find support from the decision in case of so and so, my lord. Next paragraph, my lord. Hence, I hold, in order to commit murder of deceased Sasi Bhoi, accused Girish Bhoi has entered inside her house being armed with an axe. Therefore, the offense under section 449 of IPC is clearly made out. Hence, the prosecution is able to establish the offense under section 449 of IPC against the accused beyond all reasonable doubt. In the result, I found the prosecution failed to establish the offense under section 302 IPC against the accused Girish Bhoi beyond all reasonable doubt.
No, what was the axe seized? The axe was seized and the blood stain the axe. Did it match the...
The axe was seized, my lord. But the Caesar witnesses have turned hostile. That is one ground, my lord. But my lord, as far as PW...
No, 1 minute.
Yes.
So what about the serological evidence? Was the axe sent for chemical examination?
Yes, my lord.
No, para 37. Just read para 37.
The C report reveals no bloodstain was found on the axe. Even if the seizure of the axe is believed, but the absence of bloodstain, the axe creates suspicion regarding the... My lord.
1 minute, please.
Yes, my lord.
Please, you have read it several times, so you're fully prepared.
No, my lord.
We're just reading for the first time. So kindly be patient with us. Yes.
Even if the seizure of the axe is believed, but the absence of bloodstain in the axe creates suspicion regarding the use of the said axe for committing murder of the deceased when the depth of the injury was 4 inches. So prosecution failed to establish that the MO1 was used as a weapon of offense in this case, my lord. My lord.
What is the dying declaration here?
Dying declaration, oral dying declaration before the husband.
What is that?
That.
Let's read that. Let's read the discussion there.
My lord, I will take your lordships to PW6 deposition, my lord.
No, there must be a discussion of that in the impugned judgment.
Yes, ma'am. My lord, at Para 12, my lord. It starts from para 12. Specifically, my lord, it's written.
Hani Dechi. Hani Dechi is what? Oh,
My lord.
no. Did she name him?
$39, my lord, the learned court below has very, in a very short way, he has dealt with it. Para 39, last paragraph, my lord. But deposition, my lord, PW6 has clearly stated, my lord. If I'll take a deposition.
Notice returnable. 21st November.
Equalist item 50.
Your lord, admitted?
You issued notice.
Issue notice, yes.
Item number 50.
Pass over.
Item number 51.
Yes, my lord. I may please you run your constitution. In this PIL, I have filed one IA, by number 10,673 by 22. That may kindly be please be allowed. And the amendment petition will be filed in this week.
No, but you've not made any representation.
I have made the representation.
Annexure 4 at page 26.
What is that issue? You have delivered it.
Pardon?
You have delivered it. Yes, the received ADM revenue has received.
No stamp, nothing. Anyway. The petitioner's representation dated 22/9/2021 be examined by the collector Puri.
Yes, my lord, collect.
And after notice to the petitioners and giving the hearing, the reasoned order shall be passed thereon by the collector Puri not later than 28th November 2022 and be communicated to the petitioner not within a week thereafter. Court clarifies it is not expressed in view of the matter. Petition is disposed of.
Weekly list item number 52.
May I please alert? My lord, petitioner has approached this honorable court to agitate his grievance. The petition's land, Stitiman land, is blocked by the opposite party number 5 and constructed a wall, my lord. For that reason, petitioner unable to passage the main road, my lord.
You have made your representation.
Annexure 6, mine.
All right. Petitioner's representation bracket annexure 6 be examined by the NHAI.
My lord.
Project Director NHAI. Project Implementation Unit Baleshwar. Bracket opposite party number 2. Bracket. And after notice to the petitioner as well as opposite party number 4, as well as the NHAI authorities themselves. No, you see, opposite party number 4, a reasoned order shall be passed not later than 10th October 2022. The order shall be made available to the parties within a week thereafter. The court clarifies it is not expressed in the matter.
Weekly list for orders item number 53.
Hello, item 53, I seek a short adjournment as Mr. Panda is not well. He cannot. We are suffering from viral methods. No, this is for bail methods. For appellant 1.
Panda is stated to be unwell. List on 26 September.
Weekly list item 54.
54 criminal appeal for bail, your lordship. Today I am supplying the deposition copy. Lordship may call this matter next week, lordship.
At the request of counsel, the appellant list on 14 September.
Weekly list item 55.
On behalf of Insani, my lord, kindly take in this matter through an week.
What's the matter about, sir? This, whom are you appearing for? This is for bail or what is it for, sir?
You're appearing for?
On whose behalf are you appearing?
Mr. Insani. 54. 55.
Counsel, the appellant is stated to be in some difficulty today. List on 28th September.
Weekly list item 56.
May I please alert? My lord, criminal appeal matter, my lord, I am filing an IA for stay of realization of fine amount, my lord. Offense under section 302 and 498 of IPC, my lord, imprisonment for life, my lord. For pay fine of 10,000 in default to undergo further RI for 6 months for the offense.
What is the fine amount?
My lord?
What is the fine amount?
Fine 10,000, my lord, for 302.
What? Nothing. 10,000 is nothing. Why don't you pay the fine amount? What about, you're not pressing for bail at this stage?
No, my lord.
I guess it has been already admitted by your lordships.
Yes, that's what. Been already admitted. IA 987 of 2022. No, 2,000, 10,000 actually.
10,000
Yes,
and
no.
2,000 for.
2,000 for
Okay.
$2,000 for section 498A.
During the pendency of the appeal, the recovery of the fine amount shall remain stayed. The IA is displaced of. There's no other IA. All right.
Weekly list item number 57.
57, your lordships, I am appealing for the respondents, your lordships, being noticed, your lordships. I have not been served with the judgment copy and deposition, lordships. Only I have served a copy memo, your lordships. So I could not prepare the brief, your lordships.
You prayed for leave. Delay has been confirmed. Leave, your lordship will grant us leave, my lord.
Delay is already condoned.
Delay condoned. Delayed 127 days already condoned, my lord.
A complete set of papers be served on counsel for the opposite parties. Counsel for the respondents. You appear for all the respondents?
Yes, lordships.
My lord, notice was issued, my lord.
No, but he wants a copy of the petition.
Yes.
List on 29th November.
My lord, 29th of
November. Weekly list item 58.
That's item 58 is a suo moto PIL, my lords, which the Lordship Court had taken up.
Lordships, remember that it was first referred to the full bench. The Lordship said that it will be heard by the regular bench. Because this is like a regular PIL. The PIL was instituted suo moto. I have filed my detailed counter that each of the actions, they were backed by orders of this honorable court. And the Puri temple has also filed an affidavit that they have done everything in pursuance of orders of this honorable court.
Right. The present. What do you have to say?
Let's the Puri temple administration has a filed an counter affidavit. My lord, may kindly peruse that affidavit.
Temple administration has filed an affidavit.
I have filed detailed counter affidavit explaining that the property has already been sold out and registered sale deed executed in favor of the petitioner, my lord.
All right. The present PIL had been registered so much on the basis of a news item published in the Samaj dated 30th April 2014 that land belonging to the Lord Jagannath temple had been settled with the construction company with the Tahsildar Khurda, and that the said lands were single quotes Amritamohini land. Paragraph. Pursuant to the notice in the petition, counter affidavits have been filed by the said construction company, which is represented by Mr. Ramakant Mohanty, learned senior counsel. Pointing out that newspaper article did not give the true and correct picture of the actual facts and circumstances. The construction company, that is KCPL, participated in an open auction conducted by the managing committee of the Sri Jagannath Temple Puri, single quotes, Temple Authority in 1996. And the entire consideration was paid by the KCPL by 9th January 1999. The sale deed was registered on 26 November 2007. a copy which is enclosed with the counter affidavit. First of the delay is explained on account of removal of an encroacher on the land in question. Stop. Apparently, even on the date of filing of the affidavit, KCPL had not got possession of 1 acre. It is still under encroachment. Have you got it now?
Pardon, Lord?
You say in your counter affidavit
Yes.
that even to date, KCPL has not got possession of 1 acre.
1 acre and all, because there is encroachment that has not been given.
Even now,
Not given.
Mr. Mahanti confirms that even as of date, that position continues. It is further pointed out that KCPL had purchased the land in the open auction as the highest bidder at the rate of rupees 41,000 per acre, whereas the prevailing price at that time was around rupees 25,000 per acre. The quoted rate was increased pursuant to further bidding between KCPL and the next highest bidder before the court in OJC number 8073 of 1997. The person occupying one portion of the land in question is stated to have filed civil suit being CS number 274 of 2008 in the court of Civil Judge Senior Division Khurda against KCPL, which is stated to be pending adjudication. Full stop. Paragraph. A reference has been made by KCPL in its affidavit to the judgment and order dated 23rd March 2010 passed by this court in OJC number 3242 of 2008, where inter alia it was observed as under. Take from internal page 7 of the counter affidavit of this construction company, the quoted portion. Paragraph. Counsel for the temple administration confirms that a sale notice was published on 8 January 1996, inviting applications from prospective purchasers of the land that the temple had decided to sell to an extent of AC 112.16 DEC at Moza, Chatrama, Khurda, after approval of the state government. Full stop. The auction pursuant thereto was held on 8 June 1996 after sale through private negotiations did not succeed. Also, it is confirmed that KCPL participated in the auction, bid for rupees 41,000 per acre, and became the highest bidder. Full stop. It has been confirmed that the present market value of the purchased property at the stage of filing of the affidavit by the state, that is 17 June 2014 was around there's a portion with the mention the value of the property. Where is that? No, the passage. The counsel for the state also does not dispute the above factual averments in the affidavit of the construction company and the temple administration. So, that view of the matter, no further directions are called for in the present petition, and it is disposed of as such.
There's a second matter. Just a minute. There's a second matter attached to it, which is not different. There also have some shortfall. Actually, the file was lost. I have taken a copy from Mr. Mishra. Lordship may grant me some time. I'll take instruction. He says that it has been given.
No, this is 1954.
Yes, ma'am. 1954.
That's your petition.
Yes, my petition.
This is not a PIL.
No. There's a counter affidavit which they have filed. They have said that we have complied with. I have taken a copy. Your Lordship may grant me some time.
No, so this is not a PIL.
No, this is not a PIL.
So it can go before the roster bench. Petition 1954 of 2009. List before the roster bench on 14 November.
Published.
We can list item 59.
May I please, Your Lordship? Your Lordship, the appellant herein seeks to challenge the order dated 13/2/2015 under Annexure 1. Your Lordship, may kindly have a glance at page 30. Page 30, Your Lordship. I will read out the order, Your Lordship. That is heard Sri Patnaik, Learned Counsel for the petitioner. The petitioner has a limited grievance in the writ petition that in spite of submission of complaint against one Arun Kumar Tubrewal, opposite party number 6, the opposite party number 1 has not taken any action on the same, and as a consequence of this, the petitioner is suffering a lot. It has been stated that considering the limited request of the petitioner, this court disposes of the writ petition with a direction to the ICAI, opposite partner, to look into the grievance of the petitioner as
so you're Arun Kumar Tubrewal, is it?
No, Your Lordship. I'm the institution. I'm the institution. ICAI, Your Lordship.
So how are you prejudiced by this?
Your Lordship, the authority to whom it has been directed to look into the complaint I wasn't made a party to the main petition.
It's all right. How are you? Agreed. That's why. How are you?
Your Lordship, I will appreciate, Your Lordship. How am I? It was given that to take a decision therein in accordance with law of giving an opportunity of hearing to the opposite party number 5. Your Lordship, the statutory provisions speaks that there is a prescribed procedure to conduct of cases as to if a complaint has been received, Your Lordship. So we subsequently, what has happened, they have not implemented us as a party. If Your Lordship sees page 7.
No, but there was no stay of the impugned order.
No, Your Lordship.
So when bottle remains, it's a very old order now.
Yes, Your Lordship.
Why should we interfere now? There's no stay of it. This was all to be completed within a few weeks.
What has happened, Your Lordship? The provision states that there is a prescribed rule that
whatever it is, sir. This order, you were to complete the whole thing, take a decision.
That is against the express provision in the statute.
Sir,
statute
that was not stayed. This order of 2015 was not stayed.
No, Your Lordship.
It is 7 years now.
Yes, Your Lordship.
This inquiry was to be completed within 6 weeks.
Due to the pendency of the list, Your Lordship, it was not because the direction that has been given to
So you have granted yourself a stay.
No,
you have declared that this order is wrong because of grounds A, B, and C. You have yourself given yourself a stay.
No, Your Lordship.
Then
we have extended our what we have, Your Lordship, as per the statute. We have done our part, that we have, after receiving a complaint on 24/9/2013, we passed it on to the respondent, number 1, to seek a written statement from the respondent, and after receiving of the written statement, we send it to the complaint back to file a rejoinder, if any, and as per the statute, we have to form.
You're conducting this inquiry now for 7 years, even according to your statute.
Due to lease, it is pending, Your Lordship.
So very convenient. So first of all, this is extremely convenient, sir. First of all, there is no stay of the impugned order.
Yes, Your Lordship.
But you have granted yourself a stay. You have said, no, as long as some writ appeal is pending, I don't have to implement the order. Then you say, no, I will not. Then you say, no, I will not go as per what the single judge says. I will go by my statute. I'll follow that procedure. But even that procedure you don't complete. Why? Because writ appeal is pending.
We have.
This is very convenient.
Your Lordship, we had made a progress, but during the pendency, we couldn't appreciate the single judge order because of the statute.
No, you had abandoned the single judge's order, which is why you went by your statute.
Yes, sir.
What prevented you in completing the inquiry as per your statute?
We have made substantial progress.
Substantial progress. 7 years is substantial progress for you. Keeping an inquiry like this pending for 7 years is according to substantial progress. You have a 10-year plan.
No, Your Lordship.
What is this?
But because of this,
you are an institute of chartered accountants.
Yes, Your
You
Lordship.
take 7 years to complete an inquiry.
Because, Your Lordship, because of the list, we couldn't progress.
What is this because of list? Because of list. Was any stay granted for you?
No, Your Lordship.
Then what is this because of list? This is the most lame excuse I've ever seen. No stay is granted by this court.
No, Your Lordship.
Then what is this because of list?
If Your Lordship may kindly appreciate the fact that
we have to appreciate everything, sir. You have to simply sit pretty. You do not have to get a stay from us, but you have to grant a stay to yourself. And anything asked, you have to say list. You have been told this wonderful word. Keep saying list before the court. Somehow the court will appreciate everything you're saying. I love the writ appeal. No? Only one submission. List is pending. This is clear abdication, sir. You're abdicating your statutory function. You're abdicating your duty to obey an order of the single judge.
Your Lordship, I bow down to that, Your Lordship.
We shouldn't entertain this writ appeal at all. You say during the pendency of the present writ appeal,
Your Lordship,
For the last 7 years, there has been no stay of the impugned order dated 13/2/2015 of the learned single judge, which required the appellant institute to examine the grievance of the writ petitioner and take a decision, open quotation, in accordance with law. It's so clear. After giving a hearing to the petitioner and the party against whom the complaint was made. Full stop, paragraph. The expression, open quotation, in accordance with law, unquote, obviously meant that the institute had to follow its own procedures as per the statute. Full stop. It so transpires that although the institute initiated the proceedings under the statute, it did not conclude those proceedings on the specious, SPECIOUS, specious ground that the single court's lists, unquote, meaning the present writ appeal, was pending. Full stop. With there being no interim order in the present writ appeal, nothing prevented the institute from completing the inquiry as per its statute. Full stop. Consequently, the court finds no reason whatsoever to interfere with the impugned order of the single judge. The writ appeal is dismissed.
Equal list item number 60.
May I please? Turn to page 64.
Yes.
The impugned order.
Yes.
It starts from page 66, man. These are disposed at the very first day without issuing notice.
What do you say?
My lord, in this case, the petitioner has prayed for a direction to give him promotion to the post, next higher post on ad hoc basis, because the vigilance case has not been completed within a period of 13 years, though the petitioner has taken steps for early hearing of the vigilance case, and this honorable court directed to complete it within a period of 6 months, but it could not be completed within a period of 3 years also. For that reason, this honorable court also directed earlier to my learned friend to submit an affidavit how many witnesses has been examined. My instruction is that till that only 12 witnesses has been examined after transfer of the case from Sambalpur to Dhenkanal. The disciplinary proceeding has been quashed by this honorable court in the writ petition filed by the petitioner.
No, without even giving them a chance to file a reply, sir.
Your lordship, similar matters has been disposed of, and this has been passed in the opposite party is present, the petitioner is present, and your lordship may see the hard learned counsel for the parties.
We are not saying that they did not hear counsel. The ground put forth is on the very first date when the writ petition is listed, without a chance to them to file a reply.
And your lordship, the court has dealt with the similar matters which has been disposed of.
Sir, is there a chance given to the opposite party, which is the appellant before this court, to file a reply to the writ petition?
I will submit on that fact. I'll keep it next week.
No. This is the very first date of hearing.
I'll keep, because brief has been transferred because from me.
You just see that number, order number.
Well, let it be taken up next week. I will satisfy your lordship on that ground by saying all these things.
Sir, we have the entire writ petition record with us.
My lord, I can see, my lord, but
you can see. Then we'll pass it over. You see. You see it at you see it at whole lunch hour is there, sir. You show us that the counter affidavit is there. Then no problem at all.
No, my lord. I am not saying that there is
the question that is being put to you is this, sir. Are you following the question?
Yes, madam.
What is the question? What is the question?
Madam, whether a chance has been given to give the counter affidavit or not, or on the first date it has been, the order has been passed or not.
What do you want to take instructions about this?
Well, in similar cases, this same order has been passed and that has been implemented. For that reason, the petitioner can be.
How is that relevant as far as the present petition is concerned?
And present petitioner has filed the writ petition by.
No, how is that relevant? Whatever they did in other cases, in this case, should they have been given a chance to file a counter is the question.
Honorable single judge, after hearing all
So
the.
it's not enough because there are factual details which is different in each petition. Mere hearing, see, the very first day two counsel stand up, you can dispose of, provided the other side has no objection to the order.
There is nothing has been reflected in the
So
order.
how do we know? Therefore, either then the judge should say there is no objection to any of these prayers. There's no objection to any of the arguments in the writ petition. Therefore,
that is also not stated that the learned counsel for the state had objected.
Now it is clear when they filed the writ appeal that they wanted to file a counter. They were not given a chance to file a counter.
Well, nowhere it has been stated that in page 460.
Now, sir, now that they filed the writ appeal, obviously they wanted to file a counter.
And similar matters are pending, which has been posted to 28 for the other writ petitions has been disposed of.
So we'll deal with it then. You say there is no dispute that the impugned order was passed by the learned single judge on the very first date of hearing, without any opportunity to the present petitioner to file a response to the writ petition, which had factual averments, which required to be dealt with by the state, against whom the directions have been issued by the learned single judge. Full stop. This is unable to be disputed by learned counsel appearing for the respondent, since it's very obvious from the impugned order that it was indeed passed on the very first date of hearing. Full stop. On this short ground, the impugned order is hereby set aside, and the writ petition civil.
Only may I pray my submission be recorded. It has been heard, and the opposite party has
Counsel for the,
not
counsel for the respondent argues that
my submission is recorded only.
Counsel for the respondent argues that the impugned order records the fact that both counsel were single quotes heard, unquote. Full stop. However, the fact remains that there was no opportunity granted to the appellant to file a reply to the writ petition, which was essential considering that this was the first stage of the litigation. Full stop. Then the same order, writ petition civil 33216 of 2021 is restored to the file of the learned single judge and will be listed there for directions, and will be listed before the roster bench of the learned single judge for directions on 12th October 2022. By that date, the state should have filed its parawise reply to the writ petition with an advance copy to counsel for the writ petitioner. Full stop. Both parties are requested to remain present before the learned single judge on that date. Full stop. The learned single judge thereafter proceeded in accordance with law. Full stop. The writ appeal is disposed of the above terms.
We'll clearly list item.
May I pray it may be on September, kind of taken up on any date of September, because my juniors have been promoted, and similarly situated persons have already been promoted to
Not
the post.
much difference. 12th October and some last date in September.
I request your lordship any date, because I have suffered a lot.
I know.
For 13 years, it could not be that. I have come before your lordship, and disciplinary proceeding has been quashed by this honorable court only.
All right.
Thereafter, I am running before this court to get the justice, my lord. For that reason, I am praying in September, because my juniors, those who have vigilance case also,
They have to file the replies. They have to file a reply to the writ petition.
my lord, already they have made the writ appeal, so that I am praying that it may be taken up in any week of September, last week of September also.
All right.
Item 61.
61, my lord.
61. Union of India has filed a counter. Copy has not been served on this.
61, my lord. I may be excused, my lord. In this matter, 4 petitioners are there. 4 numbers of petitioners are there in the PIL. They have filed the 4 affidavits along with.
My lord, I am representing the petitioner in this case.
I am appearing for the petitioners, my lord.
But
I'm filing the copy of those affidavits along with Wakalatnama, Your Lordship. I'm appearing for the petitioner and
Sir, I think between the two of you, you have to decide who's appearing. 1 minute. Don't take. Just give it back. Give it back. Between the two of you, you first decide who's appearing for the petition. Have you taken objection? You have to take no objection from the earlier.
my lord, no communication has been sought from me.
Are you not supposed to take a no objection from him, sir?
No, my lord.
I don't know what I am new to Orissa, sir. In my long years of practice, if there's a change in counsel, consent has to be taken from the earlier counsel. I suppose Orissa, it's a different practice.
That is there, no.
It's the same practice.
Same practice.
So have you taken consent
No,
from
my
him,
lord,
sir?
I have not taken.
Are you supposed to, sir?
Yes, ma'am.
Yes. So when do you propose to do that?
I'm supposed to take consent from.
When do you propose to do that, sir?
Let it come in another day. I will.
What is your kind name, sir?
Siddharth Mishra, my lord.
Mr. Siddharth Mishra, counsel, claims that he is now representing the petitioner, but very frankly states that he has not taken consent from Mr. Omkar Devdas, who appears today on behalf of the petitioner. Full stop. To enable Mr. Mishra to do the needful. List on 17th October.
My lord, I have filed an IA for impleading certain villages that is pending.
Anyway, if you're
IA number 5949 of 2020.
Vakalat to another person, then all that we can't deal with.
There are other petitioners in there, other villages, not the villages he's talking about, the 4 persons. Other persons.
We'll take it up on the next date.
No, copy has not been served. Copy deja? No.
Item 62.
My lord, in this matter, the counter filed by both the parties, opposite party, the state as well as the private opposite party, a short adjournment will be given to file the rejoinder.
All right, rejoinder will file before the next date. List on 14th December.
Item 63.
Item 63 is also similar to item 60. Same day disposal.
The conducting counsel, my lord, has joined the panel. We have called the client for instructions. What should we keep it to some other day?
No instructions, sir. On very first day, it's disposed of.
We have called the client today, lordship. Any other day?
You'll get a time-bound disposal of the writ petition at least.
Even if tomorrow, lordship, may keep it.
There's nothing in this. It's a first day disposal. You say.
Page 100.
It is plain from the impugned order of the single judge that the writ petition Civil 25742 of 2021 was disposed of on the very first date of hearing without any opportunity to the appellant state to file a reply to the writ petition, which was based on factual averments and which required to be answered by the state. Full stop. This fact is unable to be disputed by the counsel for the opposite party. Full stop. On that short ground, the impugned order is hereby set aside, and writ petition Civil 25742 of 2021 is restored to the file of the learned single judge for being disposed of in merits, but it will be listed before the roster bench of the learned single judge on 1st November 2022. At least 1 week prior to that date, the state should have filed its reply, parawise reply to the writ petition, with an advance copy to counsel for the writ petitioner, that is the respondent herein, who should have filed his rejoinder thereto by that date. Both parties will appear before the learned single judge on that date and extend their cooperation in enabling the learned single judge to dispose of the writ petition on merits as expeditiously as possible.
Item 64.
May I please, my lord? I may be pardoned to appear in VC, my lord. Since I'm not well, my lord, I'm seeking adjournment for 1 week. I'm appearing for sole respondent.
Counsel the respondent state to be unwell. List on 19th December. Sorry, not 19th. You said 12th December.
Interim order to continue.
All right, interim order to continue.
Weekly list item 65.
May I please, your lordship? Your lordship, they have filed an affidavit today itself. They have served it to me. They have given some guidelines to all the magistrate for persons with disability. Lordship, I just want by next, on all elections, that this should be the parameters they should follow. Because if, we don't need to file a case every time to.
Correct. Obviously, they'll follow this.
They need to follow this.
Yeah. Counsel for the petitioner states that the.
In fact, I have prepared a note for your lordship. People also refer to that.
Right.
Yeah, the copy. For both panchayat election and municipal election, we have filed 2 affidavits. Let's refer to that and dispose it of.
Yes.
The allegation we have denied, and what we have done, that also is.
In an affidavit filed, in a note of submission filed by the State Election Commission, dated 29th August 2022, it is pointed out that no EVM was used during the general elections to the Panchayat Raj institutions in 2022. It was conducted by using ballot papers and to facilitate visually impaired persons. Companions of their choice were allowed with them to cast their votes on the polling day. Sub reference has been made to rules of 15 and 15 of the Gram Panchayat Election Rules 1965. So, details have been given of the arrangements made in some of the polling booths in Gajapati district. For ramps and railings. With and making wheelchairs and volunteers available to assist persons with disabilities. Paragraph. It is expected that these arrangements would be made during every election, hereafter conducted by the State Election Commission. Stop. No further directions are called for. The petition is disposed of.
Deeply obliged.
Obliged.
Weekly list pastor matter item number 50.
None appears despite a pass away. The application is dismissed for non-prosecution.
Weekly list for hearing item number 66.
Well, item 66, this was on board on 12th of August, and there was an order passed stating the release of the appellant, probably, my lord.
So this appeal is continuing as far as Rohita Naik, appellant number 2 is concerned. And I think you were asked to find out about his present status.
No, my lord, present
Because appellant number 1 has already been released prematurely.
On 5/5/2014, my lord.
Correct. That we've already made a note of.
My lord, regarding whereabout, my lord, then your lordship, we have not received any instruction as yet.
No, but you would have the report has been called for from the jail authority.
My lord, I'm sorry, my lord, no report has gone from our end also. No letter has gone from our end also, calling from report.
There is something here, custody certificate.
I'll take, my lord, your lordship, fix the short date.
No, there's something, one minute. It's there, no? Rohita Naik, 1 minute. So he's undergone 11 years so far. So, Mr. Panda, you'll appear for him?
Well, I'll take instruction because we have not been in contact with him.
Appellant number 2, you say as per the custody certificate of the Superintendent of the District Judge Angul. Appellant number 2, Rohita Nayak, has so far completed 11 years and 10 months in judicial custody. In custody. Counsel for the appellant, the sole appellant, Rohita Nayak, states that he will seek instructions at his request list on 13th October.
Weekly list for hearing
Grateful,
items 67. Item number 67.
Same thing. I think here also we wanted to find out. One of them had been released.
Yes.
This is there. Flag F.
Criminal appeal survives for appellant number 1 only.
Sulochana Kuldeep. Released from Koraput Circle Jail since 11/10/2010. So she's also been released.
On premature releasement?
That's what it says. Just show her the. It's written by hand. The convict Sulochana Kuldeep has been released from the Koraput Circle Jail since 11/10/2010.
Yes, madam. Have been released from Koraput Circle since 11.
There's a report sent by the Superintendent Circle Jail Koraput, Senior Superintendent Circle Jail Koraput, that the appellant Sulochana Kuldeep has been released from the Koraput Circle Jail since 11th October 2010. That view of the matter, the appeal is disposed of with liberty to the appellant to revive it in case he desires to have the appeal heard on merits.
Weekly list for hearing item 68.
68, for if I may please your lordship, my lord. My lord, the appellants herein are challenging the order of conviction under section 450, 302 and 34 IPC, your lordship. My lord, I had filed applications for bail, but the last bench was of the opinion that the matter would be heard. So, my lord, I am ready. If
all right, so we'll start at 2.
I'm grateful, your lordship. My lord, my lord, I have received the wakalat number. I'm just filing it right now. So
all right,
grateful.
I'm pardon to make a mention. I made a mention before court number 1, challenging the order of the Green Tribunal, my lord. The honorable court directed to take up the matter after recess, my lord. But now they have saying that matter will not go assigned to that bench. And demolition is on 31st, my lord.
We'll ask the DR to place it.
That have to come
tomorrow. We'll have it for tomorrow. Which bench?
Tomorrow, my lord.
It's number. Yes.
You have to give us a number.
I am giving the number. 22,027, my lord. I am giving the slip.
Weekly list for hearing item 68.
So if I may please your lordships.
Yes.
My lord. My lord, the case is of double homicide. My lord, it rests primarily on the child witness PW14. My lord, PW11 is the informant. My lord, PW14 is currently staying with PW11. My lord, the FIR is there at page 36. But my lord, may kindly have page 4 because it is an ODF for your lordship's convenience. My lord, the learned trial court has, to his best of his abilities, put down everything, my lord.
Right.
My lord, page 4, para 2
yes.
of the paper book. The case of the prosecution in a nutshell is that on 29/6/2013 in the morning, the informant received a piece of information over phone that his uncle, Neman Skerketa, and aunt Nehmanti were killed in the night of 28/6/2013. He, along with his father, thereafter proceeded to the house of the deceased. He found the dead bodies of his uncle and aunt lying there with several bleeding injuries. He noticed they were killed as a result of assault on them by means of an axe. He learned from the villagers that prior to the incident, there was a quarrel between the accused persons and his uncle with regard to a bullock. The informant learned from the grandmother of Ashish that in the preceding night, the accused persons had left home in the midnight. The informant suspected the involvement of the accused persons in causing the death of the deceased persons. Now, my lord, why this was relevant is, my lord would note that on the FIR, the informant does not state that these people have killed. My lord, this is relevant because she states in her deposition, which I'll take to your lordships, that she had learned from PW14.
Let's read it, then you argue.
My lord.
Let me read the evidence.
My lord, may kindly have PW11, the informant, which your lordships would find at page 67 of the paper book. My lords have it?
Yes.
May I continue? I am the informant in this case. Deceased Nemansh and Nemanti were my uncle and aunt respectively. I know the accused person standing in the dock. On 29/6/2013, while I was present in my official quarters, which situates under town PS Sundargarh, I received a telephonic message from one Subradani Lakra, the then Saib Narpanch of Diagaon Panchayat, about the unfortunate incident that led to the death of my uncle and aunt. I was told by her that my uncle, Nemansa Nemanti, were brutally murdered by culprits in the last night. Immediately thereafter, I, along with my father, proceeded to the spot and reached there by 7:30 a.m. Going inside the house of the deceased persons, I found the dead body of my uncle Nemans lying on a cot with bleeding injuries on his neck, shoulder, and left hand, with two of the fingers having been chopped off, and the dead body of my aunt lying under the wooden bed in a pool of blood with injuries over her person. Thereafter, I, along with my father, went to the house of the accused, Ashish Kerketa, who happens to be my first cousin, being the son of my maternal uncle named Imrian Kerketa. Accused Ashish was not present in the house at that time. The sister of my mother was present there at that time. She told me that in the previous night, accused Ashish and his friend Saroj Dungdung had slept in the house, keeping an axe and a tapli, farsa, under their cot, and in or about the midnight, they went outside. I thereafter asked about the incident to the daughters and son of the deceased persons who implicated the accused persons in the alleged offenses. Thereafter, I lodged FIR at Tulsara PS in writing. Exhibit 11 is my report and Exhibit 11/1 is my signature. Police reached the spot at around 9:30 a.m. and conducted inquest over the dead bodies of the deceased persons in my presence and in presence of witnesses. Exhibit 8/2 is my endorsement and signature on the said inquest report in respect of Nemans Kerketa. Exhibit 12 in the inquest report prepared by the IO in respect of deceased Nemanti Kerketa in my presence and in presence of other witnesses. Exhibit 12/1 is my endorsement and signature. I have been examined by police in connection with this case. Cross-examination by accused Ashish. My native place is village Tilike Kani under Kinji Kela PS. The occurrence village is about 65 kilometers from my native village. The occurrence village is about 35 kilometers away from Sundargarh town. I received the telephone call on 5:15 a.m. I went to the spot in my motorcycle. I reached the occurrence village at about 6:30 a.m. I was pulling on well with accused Ashish Kerketa. My relationship with him is still intact. I reached Talsara PS at about 7:45 a.m. and reported the matter there in writing. I was examined by police at the spot. I have no direct knowledge about the occurrence. I had not a cross-examination by STC for accused Saroj. I had not informed the police about the incident soon after receipt of the telephonic message about the death of my uncle and aunt. At the relevant time, my father was staying at village Tileikani. I have scribed the FIR myself in the occurrence village. I have been examined by the police also at the PS at the time of lodging of the FIR. It is a fact that I have not mentioned in the FIR that I learned about the involvement of the accused persons in the alleged crime from the sister of my mother and the children of the accused persons. It is not a fact that since I was not pulling on well with accused Saroj, I am deposing falsehood. My grandmother, Christodosi Kerketa, has died in the said meanwhile. My lord, this is the deposition. Now, your lordship, it rests on primarily the deposition of PW 14, my lord. Your lordships may kindly have PW 14 at page 74 of the paper book.
Yes.
My lords have it?
Yes.
The witness is a girl aged about 10 years. Therefore, before proceeding to record her evidence, I feel that she should undergo a voir dire test. The following questions are therefore put to her. Why have you come here? I have come to depose in the case of my parents. How have you come here? I have come here with my first cousin, Bijay Kumar Tirki. How is he related to you? He is the son of my aunt, father's sister. In what class do you read in? I am reading in class 5. In which school? Tileikani Kanyashram. What are the subjects you taught there? Mathematics, social science, science, etc. Since the witness has answered the questions put to her rationally, I feel that she is capable enough to depose and stand the test of cross-examination. Hence, I proceed to record her statement. Bijay Kumar Tirki is my father's sister's son. The deceased are my parents. I know the accused persons who are present here today. Accused Ashish is my first cousin, being the son of the elder brother of my father. Accused Saroj is not related to me. He is a native of our village. On 28th of June 2013, the occurrence took place in our house in the night. At the relevant time, my father, mother, my younger brother and sister and myself were asleep. While I was sleeping with my father in cot, the body of which was woven with cotton tapes, fitta khota, my younger siblings were sleeping with my mother on a wooden bed. Hearing some sound, I woke up and saw in the light of the lamp debris accused Ashish and Saroj to have entered our house. I saw Saroj flashing a torchlight at my father. Accused Ashish then dealt blows to my father by means of an axe which fell on his right cheek and left ribs. While my father groaned, my mother got up. She implored Ashish not to kill his uncle Nemans. Then both Ashish and Saroj assaulted my mother. While Ashish assaulted my mother by means of an axe, Saroj dealt blows to her by means of a tabli fassa, then fled away. My mother asked for water. I gave her water. She drank it. The witness weeps and took a pause. My mother then instructed me that I should, after her death, go with my other siblings to my uncle's house. Saying so, she breathed her last. By then, my father had already died. I was examined by police in connection with this case. Cross-examination by Saroj accused. Every day before going to bed, my parents were shutting the bedroom door by putting a latch. Our house consists of 3 numbers of rooms. All the rooms are attached with doors. The entrance to our house gets closed if the main door of the house is closed. On the date of the occurrence, we were sleeping in the courtyard of the house, which is outside rooms. One cannot enter inside our house if the main entrance house is closed. I have not seen them as to how they effected entry into our house. It is not a fact that I have not seen the occurrence and that I was sleeping. It is not a fact that we do not have lamp in our house and that no lamp was glowing.
No, carry on.
My lord. And that no lamp was glowing at the relevant time in our house and that no such occurrence had taken place.
Oh, so was there a TIP or what?
My lord, she says that she knew them
before.
My lord, that is what she says.
All right.
I know the accused persons who are present in the court today. My lord. So, my lord, in the depositions, he says that she has seen the incident. My lord, may kindly have what happens immediately thereafter. My lord, PW12 is the witness who comes to the house instantly right at 3 o'clock after on hearing screams or otherwise. PW12 is the first neighbor of the place where the occurrence has taken place.
No, so your main thing will be to discredit the child's evidence.
Indeed, your lordship. My lord, I am discrediting her on the grounds that if she had seen the occurrence, if as she narrates as what had happened, she would have said the same immediately and not in these depositions. When it happens in her FIR, my lord, she does not name them. The informant does not name the FIR, although she states that the FIR categorically that she knew about the occurrence from the daughter, which is PW14. Your lordship, PW12 also, who is the neighbor, when they come to the house, this PW14 says that somebody has killed my father and mother, not accused and Saroj. Your lordship, I kindly have a glance on that, my lord.
Yes.
Page 70, PW12.
70.
Right. My lord. I know the informant. My lords have it.
Yes.
I know the informant, his deceased uncle and aunt, and the accused person. My house situates at 50 cubits away from that of the deceased persons. The occurrence had taken place about a year back in the night. At that time, I was asleep in my house. At around 3 a.m. in the said night, I was woken up by the children of the deceased persons. They were desperate. They told me that somebody killed their parents. I was terrified. I went to the house of my neighbor, Abhidan Kerketa. My lord, Abhidan Kerketa has not been examined.
Right.
Then myself and Abhidan informed the matter to the persons of our neighborhood, including the Naib Sarpanch, and together we proceeded to this spot. The children of the deceased persons opened the door and we entered inside and found that the dead body of the deceased Nemans lying on the cot with several bleeding injuries on his person, and dead body of Nemanti was lying under the wooden cot with profuse bleeding. Later, police came and conducted inquest over the said dead bodies and prepared inquest reports. Exhibit this are the said inquest reports. Cross-examination by accused Ashish. No house situates between my house and that of the deceased persons. My house situates closest to their house and the other houses of the locality are at a distant place. I have got no direct knowledge about the occurrence. Now, your lordship, may kindly have PW2, who is the Naib Sarpanch, who is alleged to have given the phone call to the informant and the informant coming, my lord. PW2, your lordship should find at page 55 of the paper book.
Yes.
My lord, where I am the Naib Sarpanch of the village, just prior to the deposition, my lord.
Right.
My lord. 1. I know the informant in this case. I know the deceased and his wife, deceased Nemanti Kerketa. I know the accused persons. All of them belong to my village except the informant. In the intervening night of 28/29/6/2013, I being called by one Sanatan Kerketa, my lord, PW12, of my village, went with him, my husband and other villagers to the house of the deceased persons, knocked
at their doors, which a while after were opened by one Supriya, their daughter, and saw the dead body of the deceased Nemant Kerketa lying on the cot with severe bleeding injuries, and the dead body of his wife Nemanti Kerketa on the floor of the entrance room in a pool of blood. Scared, I came out of the house. The other villagers followed suit. Cross-examination: my house situates about a kilometer away from the house of the deceased persons. Since I was a Naib Sarpanch, the villagers had asked me to go to the spot with them, and thereafter I went there. I have no direct knowledge about the incident. So, my lord, there is no corroboration of PW14 from either the person who came out into the house, which is PW12, the immediate neighbor, and PW2, who is the Naib Sarpanch. My lord would also see an interesting fact in the FIR, which I was trying to point out. My lord, PW11 in his deposition states at para 2 at page 68, if your lordships would once again have it.
Yes.
My lord, somewhere below, my lord, I'll start with para 2 itself, page 68.
Yes.
Thereafter, I, along with my father, went to the house of accused Ashish Kerketa, who happens to be my first cousin, being the son of my maternal uncle named Irman Kerketa. Accused Ashish was not present in the house at that time. The sister of my mother was present there at that time. She told me that in the previous night, accused Ashish and his friend Saroj Dungdung had slept in the house, keeping an axe and tapli under their cot, and in or about the midnight, they went outside. I thereafter asked about the incident to the daughters and son of the deceased persons who implicated the accused who implicated the accused persons in the alleged offences. Thereafter, I lodged the FIR. My lord, so he was aware about the incident that accused and Saroj have assaulted, because the daughter has already told them. But whereas the FIR, my lord, there only has been mentioned that there is probably that because of the previous enmity, because the bullock was killed by Ashish or otherwise, that the FIR, that these people might have killed the deceased persons. Your lordship would kindly see para 5, wherein he categorically states the same. My lords, I have not informed the police about the incident soon after the receipt of the telephonic message about the death of my uncle and aunt. At the relevant time, my father was staying at village Tileikani. I have scribed the FIR myself in the occurrence village. I have been examined by the police also at the PS at the time of lodging the FIR. It is a fact that I have not mentioned in the FIR that I learnt about the involvement of the accused persons in the alleged crime from the sister of my mother and the children of the accused persons. It is not a fact that since I was not pull on well with the accused Saroj, I am deposing falsehood. Now your lordship would kindly see PW 14 for a moment, wherein she says that she does not like the accused. My lord, page 77, just one cross-examination which was left out, my lord.
Yes.
My lord. Today is 17th July. I do not remember the name of the day. I was not pulling on well with Ashish since he was always scolding me. Prior to the incident, accused Ashish and his parents were having altercations. The dispute between my father and Ashish arose since earlier Ashish had killed one of our bullocks. We use kerosene as lamp oil. It is not a fact that at the relevant time, no lamp was glowing in our house, and that I had not seen the occurrence, and that I was asleep, and that since Ashish had hostility with my father, which I knew, I am deposing falsehood. It is not a fact that I am deposing falsehood at the instance of my first cousin Bijay. At present, while myself and my younger sister are staying at my aunt's house at Tileikani, my younger brother stays with my first cousin's sister at village Birkhaldi. So, my lord, at present, PW 14 is staying with the informant PW 11, and PW 11 has also brought the minor witness to the court to depose. That, your lordships, I have read down at page 74. How have you come here? Question number 2, my lord. I have come here with my first cousin, Bijay Kumar Tirki. So, my lord, when the incident was known about to the informant, it has been categorically not been written in the FIR. So, my lord, this is all a post-made-up story to implicate somebody, because the FIR is absolutely clear that I suspect accused Ashish and Saroj would have done so. Whereas, my lord, they have not been named in the FIR as the persons who have done the crime. They have only been implicated as people who might have done it because of the fact that there was prior enmity, which they learned from the mother of the accused persons. My lord, there are two more aspects wherein the learned trial court has convicted the appellants, that there was recovery under section 27. My lord, PW6 and PW10 are both the witnesses to the seizure who have categorically declined and have not supported the prosecution's case. My lord, may I kindly have PW6's deposition at the cross-examination at page 60, my lord.
Yes.
Police did not read over and explain the contents of any document to us at any point of time. I have not put my signature on any such document prepared by the police. No seizure was made by police in my presence. Cross-examination on recall on essay dated this by accused Ashish Karketa. No acts is produced today in the court. I have not been examined by the police in connection of this case. And similarly, my lord, PW10 also states in the same line that that is there at page 66, your lordship. My lord, may I continue? My lord. The contents of cross-examination, the contents of the documents over which I have put my signature at the instance of police were not read over and explained to me. The seized acts is not produced in the court today. Axes like the one which was recovered from the waters of the river are commonly available in the village. Cross-examination for accused Saroj declined. So, my lord, the 27 witnesses have refused that they do not support the prosecution's case. And my lord, the child witness, although has stated that she had informed about the same to the informant, but informant has not mentioned about the same in the FIR. Immediately, right when the PW12, who's the immediate villager, goes to the house, he states that they say, PW14 states this, that somebody killed my father and mother. Although PW14 categorically states that I know the accused persons who are there in the dock. So, my lord, the reason why PW12 would, being an independent witness, would state something otherwise. My lord, it is a subsequent narration that has been brought forward. My lord, may I rely on some judgments wherein in similar circumstances, the child witness is being prone to be saying the story of the informant or otherwise cannot be ruled out. And that is why, my lord, there has to be some corroboration of the other.
All right, that's settled anyway.
Indeed, my lord. So corroboration is not necessary, but as a rule of only for the practical purposes. And my lord, there is a judgment which I have come across, my lord, wherein in the similar lines that although the child witness had stated the same, that she knew about these aspects, but the same were not mentioned in the FIR, and therefore the child witness was said to be unbelievable. My lord, may I place reliance on? That is Manu SC. Madam, SCC Digambar Vaishnava and others versus State of Chhattisgarh, 2019, 4 SCC 522. Digambar Vaishnava versus State of Chhattisgarh. My lord, may I read from para 15 for my satisfaction, starting at page 3?
Yes.
One of the fundamental principles of criminal jurisprudence is undeniably that the burden of proof squarely rests on the prosecution and that the general burden never shifts. There can be no conviction on the basis of surmises and conjectures or suspicion, however grave it may be. Strong suspicion, strong coincidences, and grave doubt cannot take the place of legal proof. The onus of the prosecution cannot be discharged by referring to a very strong suspicion and existence of a highly suspicious factors to inculpate the accused, nor falsity of the defense could take place to take the place of proof when the prosecution has to establish in order to succeed, though a false plea by the defense at best be considered as an additional circumstance if no other circumstance unfailingly point to the guilt. 16. The court in this case has held that even if the offense is of a shocking one, the gravity of offense...
But I think what you're referring to is child witness. That's para 22.
My lord, I was trying to read that for myself so that that the prosecution also has to discharge the burden.
Obviously, that's all too.
Right, my lord.
Para 22 come to that.
Indeed, my lord. Para 22. This court has consistently held that the evidence of a child witness must be evaluated carefully, as the child may be swayed by what others tell him, and he is an easy prey to tutoring. Therefore, the evidence of a child witness must find adequate corroboration before it can be relied upon. It is more of a rule of practical wisdom than law. Thereafter, my lord, in para 23 also the same thing has been reiterated. My lord, may I read from para 36, Para 36, my lord.
Yes.
This court has emphasized the need to accept the testimony of a child witness with caution after substantial corroboration before acting upon it. It was held, it is a settled principle of law that a child witness can be a competent witness, provided statement of such witness is reliable, truthful, and is corroborated by other prosecution evidence. The court in such circumstances can safely rely upon the statement of a child witness, and it can form the basis for conviction as well. Further, the evidence of a child witness and credibility thereof would depend upon the circumstances of each case. The only precaution which the court should bear in the mind while assessing the evidence of a child witness is that the witness must be a reliable one, and his or her demeanor must be like any other competent witness, and there exists no likelihood of being tutored. There is no rule or practice that in every case the evidence of such a witness be corroborated by other evidence before a conviction can be allowed to stand. But as a rule of prudence, the court always finds it desirable to seek corroboration to such evidence from other reliable evidence placed on record. Further, it is not the law that if the witness is a child, his evidence shall be rejected, even if it is found reliable. Now, my lord, para 24, it is clear from the testimony of PW8 that she is not an eyewitness to the incident. She was aged about 9 years at the time of the incident. Her evidence is fraught with inconsistencies. None of the other witnesses have identified the appellants. Therefore, heavy reliance has been placed on the testimony of PW8. She did not tell PW1 Badridas about the appellants while disclosing about the incident for the first time. This is reflected from the FIR which has been registered against unknown persons. In such circumstances, it is risky to rely on the uncorroborated identification of the appellants at the instance of PW8, who has not disclosed about the appellants at the first instance before PW1 Badridas. So, my lord, in our case also, my lord, PW12 being the first person to whom she has narrated this story, she has not taken the names of the accused persons. She states, my lord, as I've read out, my lord, that the persons, that somebody killed my father and mother. My lord.
Yes.
My lord, may I rely on another decision on the same lights?
I think you just mentioned the para numbers. If it's the same thing, there's no need to repeat.
My lord, it is... May I give a copy to your lordships?
Yes, yes.
AIR 1992.
All right.
Oh, my lord.
All right. Yes.
May I please your lordships? Now, this is a case of double murder,
Right.
very gruesome. Almost 18 incised wounds on the lady and 8 incised wound on the husband, my lord.
Right.
This has been seen by the child, my lord. And your lordship may imagine the fathom the kind of trauma the child must have gone through at that point of time.
Right.
To begin with, my lord, let me first disagree with my learned friend that FIR, he has been named. The incident is in the midnight. The FIR is at 9:30 in the morning. The accused, both the accused have been named in the FIR. They are named, okay, not that unknown persons. So they are very much named in the FIR. Secondly, my lord, my learned friend is talking about the child witness. Here, a child witness is also the sole eyewitness. So enough duty has been cast on the learned court below to check the credibility of the child. That is why the voice diary is there, my lord, to see that whether the child has been tutored or not, whether she's credible, whether she's shaken, whether she's able to comprehend what she's saying. So, my lord, all these things have been very clearly put forth by the learned court below in para, my lords. My lord, I would like to read that para for your lordship's appreciation, my lord.
Right.
It's a little lengthy para, my lord. If your lordship will allow, I'll read it. Para 17, my lords.
Yes.
Para 17, my lords. It is profitable to have a relook at her evidence. Well, the previous para, should I read the previous para? Let's start from 17.
All right.
It is 17, it is profitable to have a relook at her evidence. She has stated that on 28/6/2013, the occurrence had taken place in their house in the night when her father, mother, younger brother, sister, and herself were asleep. According to her, while she was sleeping with her father in a cot, the body of which was woven with cotton tapes, her other siblings were sleeping with her mother on a wooden bed. Hearing some sound, she woke up and saw in the light of the lamp debris which has been seized, my lord, accused Ashish and Saroj to have entered inside their house. It is her evidence that accused Saroj flashed a torchlight at her father and accused Ashish dealt blows by means of an axe which fell on his right cheek and on left ribs. And while her father groaned, her mother got up. Her mother, according to her, implored Ashish not to kill her father. And then both Ashish and Saroj assaulted her mother. While Ashish states assaulted her mother by means of an axe, Saroj dealt blows to her by means of a tabli farsa. Both the accused, according to her, thereafter fled away. It appears from evidence that her mother, while departing for good, gave some last time instructions to her and breathed her last thereafter. She has been cross-examined separately on behalf of both the accused persons. During her cross-examination, she, as it appears, has held the fort. She answered all the questions fielded at her quite aptly. I do not find her testimony to have been tinged with any falsehood. She has candidly admitted, as already pointed out, her ill feelings against accused Ashish and her parents' animosity with him. She has also given the reasons thereof. She has similarly admitted that she did not see the accused person as to how they effected entry into their house. Not only did she emphatically say that she saw the occurrence by the light of a lamp, but proved the existence of a lamp by giving a simple reply to a tricky question that they use kerosene as lamp oil. The seizure of a lamp from a house debris, as stated by PW 5, here comes in her aid. The suggestions put to her that she had not seen the occurrence at all and that she was sleeping at that of time has been flatly denied by her. She has also denied that being actuated by hostility against accused Ashish, she was deposing falsehood. She also has discarded the suggestion that she was disposing at the instance of PW 11. Examining the evidence of PW 14 microscopically, I find the same to be unalloyed. I do not find any single grain therein which would persuade me to probabilize that she had not seen the occurrence and has been tutored to implicate the accused persons falsely in this case. It is clearly from her evidence that accused Saroj is nowhere related to her. Nowhere in her evidence she has hinted at the fact that she bore any grudge against him. Had she not witnessed the incident herself, she could not be so articulate as to graphically narrate the role of accused Saroj in the entire incident. Had she been coached or tutored by any person, she, being a child of 10 years, would have definitely fumbled while speaking parrot-like. She had shown no such sign during her deposition. Her demeanor during her deposition has been recorded at para 2 of her examination. It shows that while speaking about the incident, she, at a particular time, broke down and took a pause. Had she not seen the incident of her father and mother being assaulted savagely before her eyes, and had she been tutored to speak about the same, her conduct before the court would not have been so natural. She has not dithered a bit while implicating the accused persons in causing the death of her parents. It seems to me that before the court, she, while narrating the incident, has taken the lead of her emotions, which she has stored for long. Her evidence, to say the least, is flawless, since it is all the more believable in view of her throwing light about the dispute between her father and accused Ashish that arose from the latter killing of father's bullock. As stated by her, accused Ashish was none other than her first cousin Had there not been any rivalry between him and her father, it would not have been difficult to imagine his having acted in the ways as has been related by her. But in view of the presence of such rivalry between them, the evidence of PW14 appears to be convincing. On such analysis, I find that even if PW14 is a child witness, her evidence being cogent, convincing, and trustworthy inspires confidence. Therefore, the same cannot be shrugged up as one deposed by relation of the deceased out of vendetta and with object of seeing them convicted. So, well, this is a very long, exhaustive description of how the child has behaved and how the court was convinced in its own wisdom the child has not been tutored and she has actually seen the incident of this savage, brutal, gruesome murder of her parents, my lord.
Yes.
So, and I would like to reiterate, my lord, my learned friend was citing some incident, some decisions, my lord. Here, this is a clear case where the child witness is the sole eyewitness, and as your lordship's notes, if the eyewitness is to be believed, conviction can be solely based on it without any corroboration, my lord. Secondly, my lord, thirdly, my lord, FAD, my lord, the names are there. Thirdly, my lord, there is a PW
10.
My lord, no, PW.
It's at 10.
PW 15. The brother of the deceased, he speaks of the just previous conduct of the accused. Why I'm trying to bring PW 15's deposition before the lordship is that it shows that the accused are intoxicated before, they had a grudge, there was a previous motive, and it has been enhanced by the fact, aggravated by the fact that they had taken liquor, my lord, just the previous night. So, my lord, if your lordship will kindly appreciate, I'll read this deposition 15, my lord. He's also related witness distantly. The informant is a son of my sister. The deceased are my brother and sister-in-law. Accused, my lord, at page 78. I know accused Ashish is the son of my elder brother. I know accused Saroj Dumdum. On 28/6/2013, the occurrence had taken place in the night in the house of the deceased persons. I was then in the house of my mother, which is situated in the village of my brother. The house of my mother situates about 400 meters away from the house of the deceased persons. On that date, at around 4 p.m., I had given a 100 rupee note to the accused Ashish, who was staying with my mother, to bring potato and dal. Ashish, he came back with accused Saroj with those articles at around 9 p.m. When I asked him as to what happened with the rest of the amount, he told me that he had taken liquor without amount. Thereafter, both Ashish and Saroj took their meal together and slept for half an hour. Thereafter, both of them went out of the house with one axe and one tabli. When I asked as to where they were heading, Ashish told me that since the mother of Saroj was blind, he was going with Saroj to his house to sleep there. After a while, I heard the groaning sound of my brother. A little while thereafter, some of the villagers headed by the Nair Samraj came to my mother's house and reported about the death of my brother, Nemans, and his wife, Nemanti. I went to their house and saw them to have been killed. I have not seen the occurrence taking place. I was examined by the police. And that is not relevant. What I'm trying to appreciate, what my trying your lordship to appreciate is that the conduct of the accused just before the incident, which is brought before the learned court below, that they were intoxicated. There is a motive which has been clearly attributed by the eyewitness as well as the villagers. The informant has also gathered information from the villagers also, that there was a previous enmity and previous quarrel had taken place between them due to some bullock dispute, my lord. So there was a clear-cut motive. There's a credible, cogent eyewitness version. Maybe she's a child, but the court has taken that into consideration, my lord. And there's an affair accused who have been named properly, my lord. So under this circumstance, no other corroboration is required. Yes, my lord, admittedly, the scissor witnesses have turned hostile, so I'm not harping on that. My humble submission that I would like to stress on the eyewitness of the child who has seen this ghastly incident in her own eyes and it narrated it properly before the learned court.
Yes, please.
My lord, may I just rejoin in
Yes,
2
yes.
points, my lord?
Yes, yes.
My lord, had it been a scenario that the child witness had seen the occurrence, the moment when PW12 comes to the house, it would have been narrated. had it been the scenario, then the FIR would not have been that there was a dispute between them, and therefore I'm presuming that they would have killed my uncle and aunt, because it is stated in the FIR, it is stated in the deposition clearly that I had spoken to them before lodging the FIR. That, my lord, therefore there is definitely some doubt about her being tutored, your lordships. My lord, the child witness, had she known about the occurrence, my lord, may kindly see one more reason as to why, my lord, she might not have seen the occurrence would be my submission. My lord, may kindly see that she states about only 2 injuries to have fallen on her father. Whereas, my lord, there are at least 8 injuries that are there to the father. And so far as it concerns the mother, my lord, there are 18 stab injuries and even to the head and neck. So, my lord, in that state of mind, my lord, to even to take a glass of water and then to proceed and to state that you go with, you take your siblings and go to your uncle and aunt, my lord, I believe that that would not be a cogent story. My lord, with 18 stab wounds and that too with axes and farsas, my lord, it would be a case of a sudden death. And my lord, if I ask myself a question that, my lord, if such is a scenario that somebody has killed the mother, there's another child who's sitting there. She would have, because she states that she was sleeping there. Once she was sleeping there, my lord, as to why would they be left out? If somebody is drunk, they would have also killed this child.
No,
So as
these are all
presuming that the
presumptions.
child is
These are
asleep.
presumptions, man.
Yeah.
These are all
My lord,
stories
my lord,
you're
that is what she states, that I was sleeping with my mother on the other cot. So, my lord,
No, she's sleeping with the father. The other 2 children are sleeping.
Yes, my lord.
Yes,
So,
other 2 children were there, but they were too young not to be produced before the court, my lord. She is 10 years old, and she's
my
a
lord,
10 years
she
old.
admits candidly that she has not seen how they've entered the house. How they exit has also not been narrated, your lordships. Or, my lord, why I'm stating this, but because had there been a scenario, then in the FIR, these people would have been named as the people who have committed the crime and not as people who they are suspecting to.
Or,
my lord, and PW being the first person does not state anything. There's no corroboration from PW 12, wherein the PW 14 has stated that somebody killed my father and mother.
all right.
My lord.
Oh, orders reserved.
I'm grateful, your lordship.
All right.
Item number 69.
Item 69 on behalf of Mr. John Kumar Raut, Senior Advocate, pray for 2 weeks after mile.
No. Who he's appearing for whom?
I am appearing for appeal and mile. Is suffering from chicken pox, my lord.
Sorry?
So, Mr. Roth suffering from chicken pox, my lord.
Counsel for the appellant is stated to be unwell. List on 6th December.
Quick list item 70.
I'm appearing for the respondent in item number 60.
All right.
Item number 70.
On behalf of Mr. Sadangi, my lord, next week.
Why, sir? LCR is available. The paper books be prepared within 4 weeks and supplied to counsel of the parties. Include in the list of final hearing thereafter.
Next question. Weekly running list for hearing item number 1. GA 28 of 1994.
Look, first and foremost, my lord, respondent 2 and 3 have died in the meantime, my lord.
Right.
2 and 4, my lord.
2 and 4. No?
2 and 4.
2 and 4. The appeal stands abated against them.
Right.
Well, there's a little background to this case, Madam. I'd like to, Your Lordship like to hear it.
Yes, absolutely. 94.
My lord, in this particular appeal, my lord, I am for the instruction I received in the morning to appear on behalf of respondent number 3 after elevation of my learned senior to the bench, my lord, Mr. Mahapatra. My lord, I just now received the brief, my lord.
Let's see what she says.
Well, there's a little background to this case, my lords. My lord, this is a case of double murder at Puri. It was four accused persons stood trial under section 30234, and they were acquitted, my lord, in 1993. After this order of acquittal, we had filed this GA number 28 of 1994, and this GA was disposed of on 25/2009 by this honorable court, setting aside the order of acquittal and convicting the respondents under section 302 and 34 IPC, my lord. That is on 25/2009. Against this, they had preferred a criminal appeal in the Honorable Apex Court. Honorable Apex Court remitted the matter back to the Honorable High Court for rehearing and had requested the Honorable High Court to release the 4 of the accused persons on bail. So that is how it stands for hearing today, ma'am.
So of the 4, 2 are dead.
My lord?
Out of 4?
Out of 4, yes. Well, the grounds that we have taken in the appeal, my lords, if I take a
first tell us the incident and
yes, well,
then we go to the grounds.
The incident is PW1 is the informant. He has given a very direct version of the incident, my lord. But what has happened, my lord? Can I read the prosecution story from the PW1 aspect, my lord? He has given the detailed incident. I know the accused persons. The deceased Narayan Panda is my father, and this is Kasinath Panda is my brother. The occurrence took place on 11/8/1990 in between 1:30 to 2 p.m. in the premises of kerosene depot of Rampal Saha near Mausima Temple at Grand Road, Puri. I was working as a hawker in the kerosene depot under Rampal Saha for last 3 years. On 8/8/90, Rampal Saha terminated my hawkership and refused to deliver kerosene. On 10/8/90, at about 1 p.m., I had gone to the kerosene depot of Rampal Saha, but he refused to make over kerosene to me. When I then went to supply inspector, he assured me of supply of kerosene from the depot of Saha, and I returned home. While returning to a kerosene depot, another kerosene hawker, Dayan Patra, informed me that accused Munna Kaura had assaulted my younger brother, Kasinath Panda, in front of the gate of a kerosene depot. This is 1 day prior to the actual incident. Kasinath Panda in front of the gate of the kerosene depot. On return home, I found my younger brother, Kasinath Panda, bleeding from his left cheek. He told me that he was assaulted by accused Munna Kaura on his way home near the kerosene depot of Rampal Saha. I, along with my injured brother, Kasinath, and one Bullu Panda of our Sai, went in search of the supply inspector, Satyavadi Kaur, who was then talking with Rampal Saha at the kerosene depot. While I was narrating the incident to the supply inspector, accused Munna Kaur appeared all of a sudden and delivered me a slap and also throttled me my neck. Bullu separated us and went back home. On the next day, this is prior to the incident, on the next day, that is on 11/8/90, at about 11 a.m., Simanchal Patra, he is also in PW, my lord, a friend of Kalu Saha, the grandson of Rampal Saha, came to me and told me that Kalu Saha had sent for my father, my brother, for a compromise. Me, my father, and my brother for a compromise. My father first went to the kerosene depot, and Kalu Saha asked me to come with kerosene license registered and money to receive kerosene. My father returned home. I, along with my father, returned home. I, along with my father, brother, Kasinath, and Simanchal Patra, went to kerosene depot. It was about 1:30 p.m. My father and younger brother stood near the gate of the depot. I alone went inside and met Karusa. To my surprise, Karusa told me that he had not at all sent for us. At that time, I heard the voice of my younger brother coming from outside that he was being killed. I rushed towards the gate, but at the door of the room of Saha, I saw that accused Munna Kara thrusting a gupti into the abdomen of my brother. Kasinath, my brother ran into the room of Saha for life and fell down unconscious there. My father rushed in crying for help and stood near the door of room accused Munakar, who had chased into the younger brother to the room and thrust the gupti into the chest of my father. My lord, he is the witness who has seen assault on both his brother and his father. The other three accused persons, namely Budha Ponda, Kalia Ponda, and Rabi Behera, were brandishing their respective weapons standing near the gate of the depot in order to prevent entry of outsiders. With brandishing with a big gupti, Kalipanda with a knife, and Rabi Behera with one iron rod, preventing outsiders to come into our rescue. My father fell unconscious on a cot, but inside the room. I bolted the door of the room in order to prevent the entry of the accused persons. My brother and father were lying in pools of blood inside the room. Kalusa was present inside the room. 2 to 3 minutes thereafter, outsiders came and asked me to open the door, saying that the accused persons fled away. I opened the door. Thereafter, I carried my injured father and brother to the district headquarters hospital. The doctor at the outpatient department declared both my father and brother dead. The police arrived in the hospital at that time and narrated the incident to the town inspector Puri at the hospital. He reduced it to writing or read over and explained to me the contents thereof to me, and I lent my signature thereon. Exhibit 1 is the FIR I have lodged, and Exhibit 1 by 1 is my signature in Exhibit 1. The police held inquest over the dead body of my father and brother on the veranda of the hospital and prepared the inquest report. The dead bodies were sent for postmortem. On the next day, I pointed out the spot to the police at about 6 or 7 a.m. Accused Munakar is known as Madhusudan Kar. His elder brother Madan Mohan Kar is kerosene hacker under Sa. So, Mayor, here the aspect that Munakara has done it at the behest of Rampal Sa is evident from here, my lord. Munakar is known as Madhusudan Kar. His elder brother Madan Mohan Kar is a kerosene hacker under Saha, under which the present PW1 also a hawker in accused Munakara, Buddhapanda and Kalyapanda belong to Dolomandap Sahi and Rabi Behera belongs to Matimandap Sahi. I know them prior to the occurrence. I knew them prior to the occurrence. They also frequently visited the kerosene depot of Kalu Saha. I did not know accused Rabi Behera name the time of occurrence. I had named him as one Sarangi in the FIR. I came to know his name after the occurrence from my maternal uncle. The witness identified the accused Rabi Behera in the dock as a person he had named Sarangi. I have also identified accused Rabi Behera in the TI parade conducted by the Magistrate First Class Puri on 5/9/90. I have signed the TI parade report. Exhibit 2 is my signature on the TI parade report. Kalia Panda is also known as Jambeswar Puja Panda and Budha Panda as Om Puja Panda. MO1 is a Gupti with which Munakara killed my father and brother. MO2 is a Gupti which is also known as Bujali, which Budha Panda was brandishing. MO3 is a dhoti which my father was wearing at the time of occurrence. MO4 is a Punjabi my father had put on. MO3-4 stained with blood. MO5 is a banyan my deceased younger brother had put on. MO6 is a banyan which my deceased father had put on. Both MOs and were stained with blood. Well, should I continue with the cross-examination? I'll make a submission and then.
That's right.
My lord, what facts needs to be proved for an occurrence, my lord? That there has to be crime scene, my lord. There has to be homicide. There has to be an expert opinion that an homicide has been committed. There has to be an occurrence vis-a-vis the medical opinion regarding the time of death. Some witnesses, which might be eyewitnesses or chance witnesses, a motive to the crime, any previous enmity or quarrel or dispute or any misunderstanding, my lord. So, my lord, this is a case where everything is there. There is a motive that this PW1 who was working as a hawker under Rampal Saha and Kalu Saha, who had called for a compromise, is the grandson of Rampal Saha. He had also stated in the FIR that it is a conspiracy by Kalu Saha to do away with this. He has hired these people to kill him. But somehow, my lord, I also am not able to answer why the prosecution has not arraigned him as an accused in the FIR, my lord, because there was a hint of conspiracy against Kalu Saha. So, my lord, here Kalu Saha had called them for a compromise. While the compromise, but he says when he reaches Kalu Saha, he says that I had not called you, and there the entire incident occurs. Well, the defense story was that they have disbelieved PW4 only on the ground that he has misinterpreted the weapon of offense. Well, admittedly, the father has sustained 2 injuries, one on the chest, one on the abdomen. The brother has sustained 1 injury on the belly. One eyewitness, PW4, PW7, my lord, he has seen the assault on the brother outside, and this PW1 has seen the assault on the second time inside. So there are 2 assaults on the brother. And the father, there is one once. The only discrepancy was regarding that he says he pierced a gupti, which was actually not a gupti, it was a bhujali. So on this discrepancy, my lord, the PW4 was disbelieved, my lord. But my lord, your lordship will see the PW4 has given the entire description of how the occurrence took place, how the assault, the specific overact by each of the accused persons.
Let's see the judgment and see the reasoning, please.
Yes.
Para 8.
Should I read it, ma'am?
Yes, please.
Thus, there is no dispute that both the deceased died
Para 8.
Para 8, my lords.
Peruse the LCR. Internal page 5.
Yes.
Oh, sorry. I think I'm reading the wrong one.
The prosecution judgment starts at
Correct.
running page 11, my lord.
Correct.
Well, I'll not read the prosecution story because I've already, your lordship,
I think I was reading the first round of the High Court judgment. The first round.
In the GA, my lord. Yes.
No. There's no need to go back there because that has been set aside by the Supreme Court.
Set aside.
Correct. So we'll have to go back to the time.
I can take the head of that, my lord.
No.
I'll start from para 4 if your lordship will.
All right. No, para 7, I think because the points are in para 6.
Yes, my lord.
Para 7.
The death of the 2 deceased persons are not disputed by the accused persons, PW1, Vishwanath Panda, deposes about the inquest over the dead bodies of his father and brother. PW2, Gopinath Panda is a witness to the inquest over the dead body of the deceased Narayan Panda on 11/8/90 and proves the inquest report Exhibit 3. PW3, Rabinaran Panda, witness inquest over the dead body of the deceased Kasinath Panda on 11/8/90 and proved the inquest report Exhibit 4. PW14, Sarat Chandra Chhau Patnaik also deposes that he held inquest over the dead bodies at Puri Headquarters Hospital. The inquest reports revealed that there were injuries including punctured wounds on the body of both the deceased persons. Dr. B.S. Mishra, PW7, who held autopsy over the dead bodies of the deceased persons, proves his postmortem reports. Exhibit 7 is respect of deceased Narayan Panda and Exhibit 8 in respect of deceased Kasinath Panda. According to PW7, this is Narayan Panda had a penetrating injury on his chest. And the deceased Kasinath Panda, the son, my lord, had also 2 penetrating wounds on his chest and abdomen and 2 lacerated wounds. Exhibit 7 and 8 reveal that all the injuries found on the deceased persons were ante-mortem in nature. PW7 opined that the cause of death of both the deceased persons are due to hemorrhage and shock resulting from injuries to vital organs like lungs in the case of the deceased Narayan Panda, and vital organs like lungs and main subclavian vein in the case of deceased Kasinath Panda. Thus, the evidence of both the said witnesses leaves no scope for doubt to come to definite conclusion that the deaths of deceased were homicidal and due to penetrating injuries caused by sharp weapons. Para 8, my lord. Thus, there is no dispute that both the deceased died of homicidal death. This is a case of double murder. The alleged scene of occurrence is in the heart of the Puri town. The allegation against the accused persons as serious as the murder of 2 persons in a broad daylight is ghastly and gruesome. However, the mere fact of multiplicity of victims does not in any way affect the duty of the prosecution to prove the case beyond reasonable doubt in connecting the accused persons as the author of the offense alleged. That brings before the court the determination of the most vital issues for determination. In this connection, it may be stated that the allegations as regards the occurrence of murder of the deceased persons are so intimately mixed that the 2 murders cannot be separately taken up for discussion. Also, all the accused persons have been charged under Section 302 read with Section 34 IPC. Hence, the acts of the accused persons cannot be discussed in isolation because the allegation against them is that the murders were committed in furtherance of their common intention of the accused. To attract the provisions of Section 34 and Section 302 IPC, it is not required that the actual participation of accused in dealing the fatal assault to the deceased has to be established. It also does not require that each and every one of the accused person must have inflicted a serious injury. And the question, my lord, should I read this or I'll go to the... It's not relevant. But...
Yes.
From para 11.
Yeah,
Para
in the
11.
instant case, correct.
In the instant case, the background of the case is based upon certain events preceding the date of occurrence. PW1, the informant in his evidence, states that he was working as a hawker in the premises of the kerosene depot of Rampal Saha, and the same was terminated on 9/8/90. On 10/8/90, he tried for restoration of his hawkership by taking the help of their supply staff. Prosecution has exhibited the documents marked as Exhibit 24 and 25 seized from the kerosene depot under the seizure list Exhibit 6 to unfold the dispute as regards the termination of a hawkership. Exhibit 24 is a copy of the letter dated 9/8/90 written by the kerosene depot owner to the district collector Puri, alleging that PW1 created certain disturbances in the kerosene depot on 8/9/90. When he was not issued with kerosene for certain reasons, when he was not issued with kerosene for certain reasons. Exhibit 25 is a letter dated 9/8/90 issued by the Civil Supply Officer Puri, terminating the hawkership of PW1. On the background of the dispute as regards the issue of kerosene, the evidence of PW1 shows that on 10/8/90, he was told about the assault by the accused Munakar to his younger brother, deceased Kasinath Panda, by the deceased Kasinath Panda himself. PW1 also had seen the bleeding injuries caused on the left cheek of his brother due to the assault by accused Munakar. PW1 also said that accused Munakar assaulted him by slap and throttled his neck on the I had also the deposition that there was a previous altercation and the supply inspector is not a witness in this case. PW9 Bullu alias Nirakan Panda also speaks that on 10/8/90 he had seen injuries on the left cheek of deceased Kasinath Panda and he could learn that deceased Kasinath was assaulted by accused Munakar. PW9 also states about the assault made by the accused Munakar on the informant on 10/8/90. Further, the evidence of PW1 and PW5 show that on the fateful day of occurrence day, Karusa, the grandson of the kerosene depot owner Rampal Saha, sent for the informant through PW5. As per the allegation, it was only when the informant and the deceased persons came to the kerosene depot in response to the message sent by kerosene depot owner, the occurrence has taken place. PW1 in para 15 of his statement states that on the day of occurrence, Karusa had invited them to the depot over phone, and Karusa is thickly involved in the crime. In this context, the FIR Exhibit 1 as well as Exhibit 1 as well as the formal FIR Exhibit 16 show that PW1 had made allegations against Karusa to have instigated and conspired for the murder for which the name of Karusa was mentioned as an accused in the formal FIR itself. But para 11. From the above discussions, it is seen that the prosecution seeks to establish that the termination of the hawkership of PW1 led to the certain trouble between the informant party and the accused girl. That is a motive, my lord. The further case of the prosecution is that the kerosene depot owners were the brains behind the crime. However, the police has not found any prima facie material against Karusa, for which he was not sent off for trial. PW1 and 9 allege that accused Munakar caused bleeding injury on the face of the deceased Kasinath on 10/8/90. However, the evidence of PW7, Dr. B.B. Mishra conducted the postmortem examination of the dead body of deceased Kasinath and prepared the postmortem report, does not disclose an old injury on the face of the deceased Kasinath Panda. PW7 found 4 injuries on the person of Kasinath. In para 12 of his statement, he stated that all the injuries were antemortem in nature and the time since death was 6 hours. Thus, though PW1 and 9 state about the existence of bleeding injuries on the face of the deceased Kasinath, such allegation is not supported by medical evidence. Hence, the assault by accused Munakar on the deceased Kasinath on 10/8/90 is not established beyond reasonable doubt. However, even if the evidence of PW1 and 9 are accepted on their face value, to the effect that there was dispute between accused Munakar and on the one hand and informant and his family members on the other hand, the prosecution has not adduced any evidence to show any dispute between the informant and his family members with the other accused person. In such view of the fact, the attempt of the prosecution is projecting the incidents of termination of the hawkership and the dispute with the Munakar prior to the date of occurrence are the motive of the alleged occurrence is no way connected. The accused person accepting Munakar. Also, prosecution has already given a clean sheet to the kerosene depot owners. In such view of the matter, the alleged occurrence prior to the incident dates are found too remote and unconnected to be the motive of the crime. Well, can I pause here for a second and say? Well, there's a letter of termination of his hawkership. He has confronted the owner why his termination. There's a specific allegation against him that his hawkershipping is terminated because he created some problem. His dealership has been stopped. He approaches the supply inspector, though he has not been added as a prosecution witness. He goes to the supply inspector. The incident happens in front of the supply inspector, the previous incident. So, my lord, what remains to show that there was a dispute between the parties? The fact that some relatives of Rampal Saha have not been examined, that was one of the defense ground, my lord. And they have taken that all the witnesses are interested witnesses. Some relatives of the Rampal Saha should have been examined to determine the dispute, my lord. To continue, my lord, from para 12.
Yes.
In order to prove the charges, the prosecution has come up with 3 ocular accounts about the occurrence, out of which 2 are the evidence of PW1 and PW4 before the court, and other is the FIR exhibit, which is prepared on the basis of the oral report of PW1. Though the exhibit 1 is a written account of the incident on the basis of information given by the PW1, the FIR is not a substantive piece of evidence, and as such, exhibit 1 cannot be used except for the purpose of corroboration or contradiction of the information. PW1. Thus, the ocular evidence of PW1 and PW4 are the strongholds of the prosecution case. The prosecution also has sought corroboration from the evidence as regards recovery of the weapon at the instance of accused Karya, Jambesar Punjapanda, in presence of the witnesses PW8 and 10. The prosecution also seeks corroboration from the medical evidence of PW7 coupled with this postmortem report exhibit 7 and 8. In response to the query made by the IO. Apart from the evidence on the above scores, the prosecution also relies upon the circumstances such as seizure of exhibit 26, the kerosene tally register of the informant from the depot under the seizure list, exhibit 23 dated 12/8/90, the chemical examiner report 30 in respect of the weapon of offense, MO1 and MO2, And also injuries found on the accused Buddha Panda, alias Omkar Nath Puja Panda, under injury report exhibit 28. I'll come to that later. Before delving into the ocular evidence on record, it would be pertinent to refer to the evidence of recovery of the weapon of offense, because recovery made on the basis of the information supplied by the accused is very important piece of circumstances in the criminal case, And in certain cases, such recovery have been found to be the basis of serious presumption against the accused persons. PW 14, Inspector Sarat Chandra Chau Patnaik, who is the IO in this case, in para 10 of his statement, states that on 14/8/90, he recovered one Gujali under a leather cover and one small gupti on the basis of the information given by accused Kalia alias Chambeswar Punjapanda. Accused Kalia, while in police custody, led PW 14 and the witness to Bajrang Amjha, where PMO1 and MO2 were seized on the scissor list. PW 14 states that both the weapons were stained with blood. Exhibit 10 shows that 4 persons, namely Nottabara Sahu, Chakradhara Sahu, Jagannath Sahu, and Tamprasu Sahu, were the witness to such recovery and seizure. Out of these 4 witnesses, Chakradhara Sahu and Nottabara Sahu were examined in PW 8 and 10, respectively. Both of them have been declared to be hostile witnesses. This goes against us, my lord. So,
yes.
PW is in no way supports either the seizure or the recovery. The evidence of PW 10 discloses that 2 weapons, out of which was probably a knife, were recovered from inside one wall, Almira of Amin Jagahar. PW 10 did not identify the weapon in the court. Neither the evidence of PW 8 or 10 or 14 revealed the exact information given by the accused Kalia Panda, which resulted in the recovery of the alleged offense. Excepting the evidence of PW 14, there is no evidence of record to show that the accused Kalia was in custody and he led to the recovery of the weapon. Though it is stated by PW 14 that MO1, MO2 were stained with blood, chemical examination report exhibit 30 does not disclose that the blood stains were of human blood. The evidence as regards the recovery of MO1 and MO2 falls short of standard proof to accept the same under the provisions of Section 27 of the Evidence Act. In this connection, reliance is placed on my lord decisions. I will skip if your lordship will allow me.
Yes.
So 27 has been disbelieved because of the hostility of the PW10. Now coming to the most important aspect, my lord, para 14.
Yeah.
Now coming to the most important aspect of the case, that is the ocular account of the same, the court is confronted with the evidence on PW1 and PW4. PW1 is the son of the deceased Narayan and is the informant. PW4, Samsundar Panda, is a brother-in-law of deceased Narayan Panda, who is the maternal uncle of the informant. PW1 in his evidence states that on 11/8/90, being summoned by Kalusa through Simanchal Patra, PW5, the deceased Narayan Panda, the father, my lord, went to the kerosene depot and returned. Thereafter, the PW1, the 2 deceased persons, and PW5, they have gone to the went to the kerosene depot at about 1:30 p.m. At the depot, the 2 deceased persons waited near the gate, and PW1 alone went inside and met Kalusa. Seeing the PW1, Kalusa denied to have sent for him. When PW1 was there, he heard the voice of deceased Kasinath coming from outside that he was being killed. PW1 started towards the gate, but at the door of Kalusa's room, he saw the accused Munna Kar thrust a gupti into the abdomen of his brother Kasinath, who escaped into the room and fell down unconscious. The deceased Narayana Panda came running to the door of the aforesaid room, crying for help. Accused Minakaro, who had chased the deceased Kasinath up to the room, thrusted his gupti into Narayan Panda's chest. So Munakaro has dealt gupti.
Abdomen is one and chest is the other.
Chest of the other.
Yeah.
PW1 also saw the other 3 accused persons were brandishing the respective weapons near the gate of depot in order to prevent the entry of the outsiders. Accused Buddha Panda was holding a big gupti. Accused Kalia Panda was holding a knife. And accused Rabi Bara was holding an iron rod. This is Narayan Panda fell down unconscious inside the room. Out of fear towards accused persons, PW1 bolted the door of the room from inside, where deceased persons were lying in pool of blood, and Kalusa also was present. After some time, when the accused persons had left, outsiders came and asked PW1 to open the door. Thereafter, PW1 carried the deceased person to the district headquarters hospital Puri, where on examination, the deceased persons were declared dead. After some time, PW14 and IO arrived at the hospital and PW1 narrated the incident to PW14 who reduced the information in writing, which is the FIR. Though in the evidence of PW1, it is asserted that one Kalusa was all along present during the occurrence, he has not been examined as a witness in this case. My lord, because there was an allegation against him that he is a conspirator. So obviously he has not been examined as a witness. Kalusa's name appeared as an accused in the FIR. Kalusa is not also cited as a witness in the charge sheet. In his cross-examination at para 20, PW1 specifically states that accused Munakar gave one thrust with MO1 into the chest of his father and that no accused other than Munna assaulted his father. The evidence of PW1 has to be assessed on the background of the contents of the Exhibit 1, which is the earliest version as regards the occurrence as given by PW1 himself. PW1 is the son and brother of the deceased persons respectively, and as such, he is a related witness. Hence, before accepting the evidence of PW1, he must be found to be wholly reliable and above reproach. While going to the contents of the FIR, it is seen that Exhibit 1 is a neatly written document running through sheets of papers, 5 sheets of papers. According to the PW1, Exhibit 1 was scribed by PW14 himself in the hospital itself. PW14 states that on 11/8/90 at 2:30 p.m., PW1 reported about the incident and the report was reduced into writing by SI Akila Kumar Panda on the dictation of PW14. SI Akila Kumar Parida, the scribe is not examined as a witness. After the FIR was scribed, it was sent for registration to the police station where the formal FIR Exhibit 16 were registered. PW14 further says that after the formal registration of the FIR in the police station, a copy of the Exhibit 1 was given to the informant. Exhibit 16 bears the signature of PW1 with the endorsement that PW1 received a copy of the FIR. PW1 in para 19 of his statement states that he is unable to recollect whether he was furnished with a copy of the FIR. However, it states that the signature appearing in Exhibit 1 was obtained by the police from his house. Thus, the prosecution evidence itself shows that sometime in course of the investigation, Exhibit 16 had the occasion to be in the house of the informant. In this background of the case, the contents of the Exhibit 1 have to be scrutinized properly. The FIR Exhibit 1 gives a detailed account of the events from 8/8/90 to 11/8/90. It reveals that on 10/8/90, that this is Kasinath was assaulted by accused Munakar, which caused bleeding injuries on his face. And also on the day, accused Munakar caught hold of informant shirt collar. The main occurrence dated 11/8/90 has been very minutely depicted in Exhibit 1. It is alleged that on 11/8/90, at about 11 a.m., when the informant, my lord, again that is repeated, my lord. I will take your lordship's. It continues, my lord, the same thing continues. Or should I read it, my lord? Well, let me read it. It'll be easier. At page, running page 33, my lord. The informant apprehending danger, yes, for that. The informant apprehending danger at the kerosene depot suggested alternative venues for meeting with Kalusa. However, the informant talked to Kalusa over phone, and when Kalusa assured him that they would not put him into trouble, the informant agreed to come to the kerosene depot. The informant at the first instance sent his father with PW5 to the kerosene depot at about 11:30 a.m. When the informant's father did not return till 1:15 p.m., the informant sent one Raghunath Pujapanda of Marchikot Lane to the depot. Thereafter, at 1:25 p.m., when the informant was preparing to come out of the depot, the deceased Narayan and the above said Raghu Pujapanda arrived in their house. Deceased Narayan told that Kalu Saha wants immediate solution to the dispute, they have to go to the depot with kerosene issue register for obtaining kerosene. After 5 minutes, on return of PW5 at their house, the informant, his father, his younger brother, Punna, Raghu and Simanchal Patra started for the kerosene depot with money and issue register. After reaching the kerosene depot at 1:40 p.m., PW5 went to his home. PW1 kept his father and younger brother waiting near a betel shop near the kerosene depot and went to the office. Well, here I'll pause for a second. While the other ocular witness has seen these people, his statement starts from here, my lord.
Right.
That he has seen these people standing near the betel shop and asked them. After that, he has seen the incident. PW1 kept his father and younger brother waiting near a betel shop near the kerosene depot and went to the office. When he was going into the office, one Patanjali, not examined, he was coming out of that place. When the informant Karusa not examined, Karusa not examined, Raghu Pujapana not examined, and another journalist not examined, were having discussions at about 1:45 p.m. The informant's younger brother, Punna, soaked with blood, darted in the office room crying, "Allo bolo marigali," that I'm dying, my lord, and fell flat near the almirah. My lord, blood stains have been recovered from these places, my lord, near the almirah. Number of things stained with blood have been recovered by the scientific officer from there. The informant's father came running there, shouting, "Are Maripokaila." An informant saw Munakar of Doramandap Sai was holding a bhujali. Budha Ponda, Puja Ponda holding a gupti, and Kalia Ponda was holding a knife. The three persons belonged to Doraponda Sai. The informant also saw one Sarangi, mistaken, my lord. He is that later on clarified that he was not Sarangi, and he's identified the person as a correct person in the TI parade. The informant also saw one Sarangi belonging to Hatimondap Sahi, and who is the son of stamp vendor, was holding an iron rod. The informant stated in the FIR that he could identify said Sarangi. The informant also saw blood stains on the weapon held by Munakaro, Buddha Ponda, and Kalia Ponda. The informant's brother, who was bleeding from his mouth and nose, was shivering and became unconscious. The accused persons were shouting at the informant by challenging him to murder him and by asking him to come out. At that time, Rampal Saha's servant, Joginder Swai, PW13, tried to run away, but the accused named Sarangi assaulted him by means of an iron rod, causing injuries on his head and hand. The informant tried to obstruct the accused persons by holding a chair, and at that time, when his father tried to push him back and tried to close the door, Munakara pierced a sharp bhujali which he was holding into the chest of his father. The informant's father also fell on the cot, shouting, "Marigali, Marigali." Then Buddha Pajapanda, Kalyapanda, and Sarangi came towards the informant and with their weapons to kill him. The informant and Kalu closed the door from inside and gave out that they would telephone to the police station. On this, the accused persons left the spot with their weapons. Thereafter, the informant brought his father and younger brother on rickshaw to the hospital, and both of them were declared dead. It was alleged in the affair that the deceased Narayan Ponda and the deceased Punna were murdered in... Punna is Kasinath's nickname, my lord.
Right.
Were murdered in broad daylight by Munakara, Buddha Ponda, and Kalia Ponda of Dolo Mandap Sahi, and boy named Sarangi of Mati Mandap Sahi on the conspiracy and instigation of Kalu Saha, who executed the murder by engaging this Gunda. A comparison of the statement of PW1 with the contents of Exhibit 1 reveal certain vital features which are to be taken note of
in
appreciating the prosecution case. It has become light, my lord. This. The name of the accused, Rabi Behra, Rabindra Behra, does not find place in the FIR. In the FIR, the informant PW1 does not claim to have seen any assault by the accused persons on his deceased brother, Punna alias Kasinath. However, in his statement, PW1 states that he saw the accused Munakar thrusting a gupti into the abdomen of his brother. Thirdly, in the FIR, PW1 mentioned that accused Munakar was holding a bhujali and that accused Munna pierced his bhujali into the abdomen of his father. Also, the P11 says does not speak about the iron rod assault by the accused Sadangi and Joginder Sahu. PW1 in his statement in the court implicates accused Rabi Behra instead of Sadangi. Though the name of one Raghunath Pujapanda appears more than once in the FIR to have come in contact with PW1 on the occurrence date, PW1 fails to recognize such a person and is incapable of explaining how his name appeared in the FIR. 19. The above noted features assume importance in view of the fact that none of the persons whose name are suggested to be witness to the occurrence as per the FIR itself are examined in the court to enable the court to fall back upon their version. Karusa is stated to be present along with PW1. So also one Raghu Pujapanda and one journalist were present with PW1 in the occurrence. All these three witnesses are kept apart and their non-examination remains unexplained. PW15, Joginder Swain's evidence also in no way helps to support the prosecution. PW13, who is stated to be present in the occurrence room and sustained injury in course of the same transaction, has been declared hostile by prosecution. Hence, the omission as well as contradiction in the evidence of PW1 as regards weapon of offense, assault on his brother, implication of the accused Rabi Behra, as well as presence of other witnesses are not reconciled by examination of any of the persons who were named in the FIR to be present at the spot. Also, the iron rod assault, PW3, is not supported by any injury report. Para 20. The attention of PW1 was drawn to the contents of the FIR as well as the earlier statements made under Section 161 CRPC, and it was proved that this witness admitted to state before the IO about the brandishing of Gupti knife and iron rod by accused Budha Pujapanda, Kaliyapanda and Rabi Behra at the gate. In his statement, he stated that accused Munakar was holding a Bhujali and not a Gupti, and also he did not state about the assault by Munakar on his brother's abdomen. PW1 also stated in his police statement about assault by accused Munakar to his father by means of a Bhujali. The evidence of PW14 also discloses that PW1 in his statement under Section 161 CRPC had stated about the presence of Kalusa, Raghu Pujapanda and one journalist with them at the time of occurrence. Thus, the PW1 for the first time in court states that Munakar used a Gupti in assaulting the deceased persons. This is where, my lord, we are in a difficulty. He has earlier stated in his FIR as Bhujali and now he says it's Gupti. Thus, the PW1 for the first time in court states that Munakar used a Gupti in assaulting the deceased persons. In his earlier statement, he stated the accused Munakar used a Bhujali. This change of weapon of offense in the hand of accused Munakar is an improvement as well as contradiction, and the importance of such variation in the version of PW1 shall be dealt in the latter part of the judgment. The PW1 for first time in court claims to have seen the assault by accused Munakar on his brother Kuna. The PW1 also first time in the court claims to have seen the assault by accused Munakar on his brother Kuna. This certainly is an improvement on his earlier version. Thirdly, PW1 also denies about the presence of Raghu Pujapanda and a journalist at the scene of occurrence, though their presence was ascertained in the FIR as well as police statement of PW1. The omission and contradiction between the FIR version and the version of PW1 in the court as regards the weapon of offense, the assault on his brother, the presence of witnesses are tried to be explained by the prosecution by pressing into service the decisions reported in 1983. My lord, I will not take your lordship's time regarding that.
Para 21 is about contradiction weapon of
Yes,
offense.
21. The contradiction as regards the weapon of offense used by the accused Munakar is found not to be a mere omission. In the FIR itself, the informant has made a distinction between a Bhujali and a Gupti. In the Exhibit 10, the Caesar list, the two weapon of offense have been distinctly mentioned as Bhujali and Gupti. PW14 in para 21 of his statement, PW14 is the IO, my lord. That MO1 is a Gupti and the same is never called a Bhujali. However, PW14 says that MO2 is called both Bhujali as well as a Gupti. PW1 in his chief at para 9 also stated that MO1 is a Gupti with which Munakar killed his father and brother. However, he does not refer the MO1 to be a Bhujali. Though in the next sentence he states that MO2 is a Gupti which is also known as Bhujali and that the same was in the hands of accused Budha Panda, The distinction between MO1 and MO2 can be found from the description of the Exhibit 9, that is a report of PW7, to the query made by the IO. PW7 examined the weapon on 18/8/90 and described one of them to be one Gupti within a bamboo case covered and sheath having two equal sized leather belts affixed to it with buckles. The length of affixing leather tape with buckles is 34, but length of the bamboo sheath with knife. After unsheathing the weapon with handle length 20 cm. There are two parts of the weapon, metal part, one metal part, two handle bamboo part. The sides of the metal part, one is blunt and the other is sharp, having a pointed end. Total length of the metal iron is 21.5 cm. Handle part of the Gupti is 5.5 cm in length and the brass part fixed is about 2.5 length and its circumference is 7 cm.
I think come to para 23.
Yes, last in the Exhibit 9, it was last paragraph. In the Exhibit 9, it was specifically opened by the PW7 that the penetrating wound injury found in the bodies of the victim Narayan Panda and Kuna Panda of the cases are definitely caused by the weapon described as Gupti by him, which led to the death of the victims. He also opined that the injuries found in the bodies of the deceased of this case are not possibly caused by the weapon which he described as Bhujali. The report was given by the PW7 in his statement before the court. He identified everyone to be that Gupti, which has examined. PW7 also stated that MO2 Bhujali, otherwise known as Khokri, and specifically told that MO2 is never called a Gupti. In para 25 of his statement, PW7 specifically stated that the incised wound and the penetrating wounds of both the deceased persons are not possible by the MO2. Not possible by MO2 means Gupti, my lord. Thus, the evidence of PW7 explains the reason for the change of the version of PW1 as regards the weapon of offense in the hands of the accused, Munakar, in his statement before the court. Though he stated in the affair that Munakar was holding a Bhujali and his fatal assaults on the father and brother were caused by the weapon, in the court, he tries to explain the inconsistencies by saying that the weapon of offense used by the accused Munakar was also called a Gupti. In spite of such explanation, it is seen that MO1 is a Gupti and none of the witnesses, including PW1, states it to be a Bhujali. The evidence of PW1 para 9 shows that the identified MO1 to be a Gupti, and in the same para he says that MO2, a Gupti which is also known as Bhujali with Buddha Panda, was brandishing. Thus, in spite of an attempt on the part of the prosecution to explain the contradiction as regards the nature of weapon used by accused Munakar, the same remains unexplained and PW1 is found to have contradicted himself as regards the weapon of offense used by the accused Munakar. My lord, the court has taken it very seriously, this
difference in weapons.
Difference in the weapon, my lord. But
because the description of the weapon itself is different.
My lord,
the shape, the length, everything is different.
Everything is different.
And the doctor says these injuries can be caused by one but not by the other.
But that I'll explain, that I will...
See, normally when we look for medical evidence, it is expected to corroborate the oral...
Ocular evidence, yes, fine.
Here it's not doing that. That's one point of departure. There's no perfect corroboration of the eyewitness testimony by the medical evidence.
Yes, sir.
Let's now move to para 22.
The para 23, my lord. In this context, the learned associate PP argues that the contradiction as regards a weapon of offense is a minor discrepancy and which much weightage is not to be attached to such contradiction and the PW1 version should be accepted to be reliable. However, the learned counsel for the defense forcefully argues that the contradiction is not merely a minor contradiction, but it goes to the root of the case because it tells upon the honesty and veracity of the whole prosecution case and not only that of the PW1 alone. The learned defense counsel in this regard places reliance upon the decision reported in 1992 OCR, Krishna Kuda and others, and 1981 Supreme Court, and strenuously urges that improvements made by the witnesses in the court to suit the medical evidence corrode the credibility of the prosecution versions. And when the version in the FIR made by the witness is changed while giving evidence in court to suit medical evidence, the same is vulnerable. There is much force in the argument advanced by the learned counsel for the defense. The contents of the FIR shows that the PW1 is aware of the difference between a Bhujali and a Gupti, and the nature and tenor of the FIR also shows that the PW1 was detailed in his account as regards the incident, including the occurrence itself. Hence, the attempt on the part of the PW1 to change his version by placing a Gupti, that is MO1, in the hand of the accused Munakar during his evidence in court is no doubt an attempt on the part of the prosecution to reconcile with the medical evidence. Hence, in view of the above omissions and contradiction in the testimonies of PW1 and the attempt on his part to improve on his earlier version in order to suit the medical version diminishes his credibility. He cannot be held to be wholly reliable witness, and it is to be seen whether his evidence is corroborated by any independent and reliable evidence. While looking for corroboration, it may be pointed out that as has been observed earlier, none of the witnesses named in the FIR are examined in the court. No explanation is given by the prosecution for the non-examination. The identity of the Raghunath Pujapanda and a journalist who stated to be present inside the very room from where the PW1 has seen the occurrence remains a mystery. Though PW1 states that some outsiders reached in the room immediately after the occurrence, and the PW14 also in his statement at para 22 states that he examined some of the shop owners of the vicinity, none of the vicinity of the kerosene depot on the date of occurrence, none of these persons are produced in court. PW13, Jogendra Swami has been declared hostile. The inquest reports PW3 and 4 and the dead body challenge exhibit 18 and 19, which are documents prepared immediately after the occurrence, do not disclose the names of the assailants as well as the names of the weapon used. Hence, the only corroboration that is available to be corroborative evidence of PW1 is that of Samsundar Panda, PW4. PW4 is also a related witness. His presence at the spot at the time of occurrence was on his way to call a rickshaw for a pilgrim. Thus, as per the witness, he is also a chance witness. While going to find a rickshaw, he found this is Narayan Panda and Kasinath Panda standing near the gate of the kerosene depot. The deceased persons told the PW4 that PW1 had gone to Karusa inside the depot to bring kerosene. While the PW4 was having a talk with the deceased persons, the accused persons came from the cement godown of Rampal Sar, situated at a distance of 20 cubits from the place where PW4 was standing. According to this witness, accused Kalia Panda was holding an iron rod, accused Buddha Panda was holding a Gupti, accused Robbie Behra was carrying a piece of Kasurian log, accused Munna was carrying some weapon which was concealed. The accused persons first searched for PW1, and when they did not find him, they shouted to kill this is Kasinath Panda alias Puna. Being apprehensive, this is Kasinath tried to run away into the depot, but the accused persons chased him. The PW4 says that accused Buddha Panda thrusted a Gupti into the chest of Kasinath. That is the first incident with the brother, which has not been seen by the PW1.
Yes.
Accused Rabbi assaulted this is Kasinath on the head by means of a Kasurian log. Accused Kalia dealt a blow by means of an iron rod on the face of Kasinath. This is Kasinath ran towards office room shouting that he was being killed. However, accused Munna chased him and thrusted a Gupti in his abdomen in front of the office room. Here, my lord, PW4 says he saw Munna thrust a Gupti into his abdomen of Kasinath in front of the office room. Kasinath entered into the office room, and when PW4 tried to rescue the three accused persons, Buddha, Kalia and Robbie obstructed him in front of the main gate of the depot by wielding their weapons. The deceased Narayan Panda somehow managed to enter inside the kerosene depot and went to the office room with a view to rescue his son. But as soon as he reached near the office room, accused Munna thrusted his Gupti into his abdomen. The deceased Narayana fell into the room. PW4 witnessed the assaults from the gate. After the occurrence, PW4 went to the house of the deceased persons and informed PW1's mother, and thereafter went to the district headquarters hospital where he found the deceased persons to have died. This witness, PW4, though states that he was present at the time of occurrence at the hospital where the police was present and also at the funeral ground till 1 a.m. in the night, he was not examined by the police till 13/8/90. It is 2 days, my lord. PW till 13/8/90, occurrence is on 11th, till 2 days They say they have not been.
But still, that's not usual.
13, my lord,
It's
one
still a lot.
night. That almost 13, 11 and 12 night. FIR has been lost the next day, my lord.
No. This is about the statement of the witnesses.
Yes, ma'am. The PW4 gives an explanation as regards delay in his examination by stating, and on the night after the occurrence, he had to leave for Raurkela to inform about the incident to one Lakshmindhara Panda, whose marriage was settled up with the daughter of the deceased Naranapan. PW4 states that his return only, he had a talk with PW1, and PW4 told him that the person whom PW1 described as Sarangi is in fact accused Rabi Behra. The delay in examination of eyewitness by the IO has been held to be an infirmity in the prosecution case by 1979 Supreme Court, my lord, versus Maharashtra. The explanation as regards the delay has to be reasonable and acceptable. PW4 is a related witness and a chance witness. He was examined by the police on 13/8/90. This background of the witness casts duty on the court to scrutinize the evidence of this witness with care. As per evidence of PW14 and as per the evidence of PW14, the PW4 appeared on 13/8/90 noon in his office and voluntarily told that he is a witness to the occurrence. And prior to the examination of the PW4, the IO had not found that PW4 is a witness to the occurrence. Both PW14 and PW4 state that PW4 had not disclosed about the reason for his non-appearance before the police for disclosing about the evidence earlier to the 13th morning. PW4 at para 14 of his statement states that he had not stated about his visit to Raurkela before the IO. Hence, the reason for delay of examination of this witness is too belated and is disclosed at the time of the trial only. It is also brought out from the mouth of the IO that the PW4 in his statement before the police had not stated that accused Munakar assaulted both the accused persons by means of a
Both the deceased persons. Assaulted both the deceased persons.
PW4 in his statement before the police had not stated that accused Munakar assaulted both the deceased persons by means of a gupti.
Right.
PW4 in his police statement had stated that accused Munakar assaulted both deceased persons by means of a bhujali. PW4 also had not disclosed. PW4 also not disclosed about the assault made by accused Rabi with a Kassuran stick and accused Kalia with an iron rod to the accused Kasinath. PW4 also omitted to state about the fact that his entry to the depot was prevented by accused persons. Hence, there are omissions in the statement of PW4 which he tries to improvise upon in the court. Though the IO says that PW4 mentions about the use of bhujali by the accused Munakar, PW4 in his cross-examination states that he does not know the weapon called bhujali. In para 17 of his statement, PW4 states that the accused Budha Panda thrusted MO2 into the right side chest of Kasinath Panda, and this allegation of thrusting by MO2 is not supported by medical version as discussed earlier. The statement of PW4 at para 18 reads as follows. Both Budha Panda and Munakara have assaulted Narayan. Budha Panda thrust the MO2 into the abdomen of Narayan Panda below the chest. Again says Munna has not assaulted Narayan Panda. Because admittedly, my lord, Narayan Panda, there was one injury, my lord. Kasinath, there was two injuries on the chest and the abdomen. But Narayan Panda, there is one injury. So this discrepancy hasn't brought forward by the... Thus, as per the evidence of PW4, accused Budha Panda had thrusted MO2 into the right side chest of Kasinath Panda and into the abdomen of Narayan Panda below the chest. PW7 in para 25 of his statement categorically opined that the incised wound and the penetrating wound on both the deceased persons are not possible by MO2.
All right.
Well, that the incised wound and the penetrating wound, they are different wounds. They cannot be possible by one weapon. They are possible by two weapons. Hence, PW4 is not at all found to be a reliable witness capable of aiding the veracity of PW1. His evidence that accused Munakar has not asserted this is Narayan Panda is directly contradictory to the evidence of PW1, who states that it was accused Munakar alone who inflicted penetrating wounds on the deceased persons. Thus, the evidence of PW4 does not corroborate the evidence of PW1. The belated implication of accused Rabi Bera has been explained by the prosecution to be due to a mistake of identity on part of the PW1. PW1 describes one of the accused to be one Sarangi and also to be the son of one stamp vendor of Matimonda Puri in the FIR. None of the descriptions of the person's named Sarangi fits into the description of the accused Rabi Bera. The prosecution relies upon the evidence of PW11 who conducted the TI parade in respect of this accused and prepared the TI parade report. Exhibit 2. Exhibit 2 shows that PW1, while identifying the accused, alleged that accused Rabi Bera assaulted his deceased father and brother on their legs by means of an iron rod. PW1 in para 21 of his statement fails to remember whether he made such allegation against accused Rabi as regards assault by him on his father and brother. PW1's evidence also discloses that he had been to the police station to identify Sarangi. The TI parade was held as late as on 15/9/90. The belated disclosure of the name of the accused Rabi Bera on the face of the information supplied by PW4, the inconsistency in the statement of PW1 as regards the role played by the accused Rabi Bera at the time of occurrence, the delay in holding TI parade, and also the evidence on record that PW1 had occasion to visit police station to identify certain persons through considerable suspicion as regards evidence of identification. The learned defense counsel argues that the above said infirmities, inconsistency and contradictions in the evidence of PW1 and PW4 shows that the exhibit 1 was not prepared at the time and place of stated in the same. It is urged by him that the neatly written 5 pages FIR is quite unnatural from the informant who happens to be the son and brother of the deceased persons. In this connection, he relies upon anyway, that you can skip. Yes, the formal FIR is stated a few lines.
I think it's all repetition now.
Yes,
so
27.
basically, he's disbelieved PWs 1 and 4, saying they're not reliable eyewitnesses. He says
that is regarding the
so those 2 eyewitnesses are termed as unreliable, inconsistent, and the medical evidence is not corroborating the eyewitness
with the eyewitnesses. These are the 2 evidences, my lord.
Yes.
My lord,
see, both are related witnesses, correct?
Yes, my lord. And
so related witnesses have to be tested with a great deal of caution because they have a tendency to improve.
Yes, my lord. Right, my lord.
PW4
is also a chance witness. PW4, the court says
PW4 is the most suspicious. He suddenly appears from nowhere 3 days after the incident and says, I was witness to the occurrence.
But he has, my lord, he has also given except for the weapon part, my lord, he has given a
No, he doesn't appear to be a person who must have seen the whole thing happen. That's the impression the trial court is getting.
Yes, but there definitely some discrepancy between the statements and regarding.
It should not leave you with an uneasy feeling that that's the whole problem. That uneasiness of the court is what's coming through.
And my lord, but FIR, the Ladet court below says that some my lord, omission in the 161 statement is okay, my lord. But by FIR, my lord, FIR is not supposed to be encyclopedia, my lord. It contains he has seen the incident, he has written the background.
As far as that you're right, that FIR and this doesn't tally, but there are some material omissions in the FIR.
Yes.
For a person who's actually witnessed the occurrence, for him not to mention this attack on the abdomen, attack on the chest in the FIR seems very strange.
No, there are injuries. My lord, ocular evidence and the medical evidence do corroborate each other. There are injuries in the, my lord, like the doctor says the death is due to
that the death is homicidal is not.
No, injury also. One, they say there is in the chest, injury on the chest of the father, piercing injury on the chest and abdomen of the brother. The ocular witnesses and the medical evidence do corroborate as far as the injuries are concerned. But yes, as far as the weapon offense is concerned, there is some discrepancy. Injuries are there. Penetrating insides. Well, there's a very, if I'll take your lordship to the medical. Well, I'll just complete this and then for my argument.
Actually, this is all repetition from here.
Repetition, yes.
Yeah.
Last
and then again summarizing all of this.
Yes, in other words, all the infirmities in the statements of 2 ocular witnesses have remained unexplained, and the reasons for the contradiction. I'm reading the last paragraph, my lord, para 29. being and testimony of PW1 being left unanswered, the prosecution case does not inspire the confidence to court to hold the accused person guilty of the offence.
When will
Well,
the
copy-
counsel appear? When will the counsel be ready to argue this?
Learned Senior is appearing for respondent 1.
No, I was appearing, my lord, in the initial government appeal,
Ah.
which was allowed, and appeal was SLP was filed before the Honorable Apex Court. But after returning the same, and after the case was returned, I don't know who was appearing. Because I was appearing, my name appears. So, but whatever my learned friend has submitted, my lord, considering the principles of appreciation with a government appeal, in a government appeal under section 378(4), my lord, there must be some flagrant miscarriage of justice. That is the law. And that has been taken note of by the Apex Court while remanding the case. And keeping the case in the touchstone, my lord, there may be a second conclusion. But can it be said to be the appreciation made by the London trial court which is based on error of record, which is not can be taken to be wrong appreciation or following the wrong principles of law? No. It is again a prudent, a court can appreciate it in a different manner.
And merely because two views are possible. Same thing.
The conclusion is very clear. So once acquittal has been made, considering the facts and considering the
Melody, you lot.
and that is my lord, that is particularly when acquittal has already been leveled. That is there. Appreciation of evidence has already been made by a trial court, and already they have been acquitted with a stamp of that they are innocent, they are not guilty, and prosecution has failed.
That is where 378 comes into play, my lord. We have come and.
But when, yes, if the trial court will do some illegality, impropriety, wrong appreciation, or which will otherwise come to be flagrant miscarriage of justice, that has been the language used by the Apex Court. So my London friend may say, yes, that is the flagrant miscarriage of justice. This material was available, has not been taken into consideration. It again, whatever my London friend says, it's all appreciation of evidence again, reappreciation. But however, I am not the counsel now, because I was the counsel. After the case was remanded, I have.
No, but he's up here only for one.
I am
one
for respondent number 3 only.
Which is Kalia.
Yes.
Who are the two deceased?
My lord, appellant number.
My lord, 2,
Buddha.
2 and 4.
4.
Oh, Ravi
Buddha,
Bera.
Omkant Pujapanda, and 2, my lord, the mistaken identity person.
Ravi Bera, that's
Ravi
RK.
Bera.
My lord,
So appeal is abetted against.
So Munna and Kalia are anyway the two.
Munna, Madhusudan, he is the main assailant, and Kalia, Jambesar, from whom Caesar was there, but Caesar has not been properly.
So what do we do for Munna, then somebody else is to appear?
My lord, if your lordship sees the last order, on the last order, I believe the report was called for by the local police so as to respondent number 1's position is.
My associate was verifying that the report of the police is there, and also Mr. Kishore Misra has appeared for respondent number 1.
That is 21/5, 2021.
Because when earlier the matter was listed, the same question was put by the Honorable Court. I said, no, I have no instruction. So instruction was sought first.
No, I have instruction as late as March 2021 regarding the appellant number 1. It is ascertained, it's a respondent number 1. It is ascertained that Munna Madhusudan Kar, son of so-and-so, now is working at Sri Jagannath Temple with his hereditary Seva Puja of Lord Jagannath. We do not found any criminal antecedent or CA verification in those years by him.
Oh, so Munna is a sevak, is it?
Munna is a seva.
Sevak. Oh.
Very influential seva. And Buddha is dead. And as far as
Kalia.
Kalia Jambeswar, my lord, he's alive.
Kalia
I have instruction to appear.
My lord, today since there's a positive time, your lordship will allow me 10-15 minutes.
No, anyway, you have to hear them. I'm saying he anyway wants an adjournment for another day.
Your Lordship.
Next week, any day, Your Lordship.
Next week.
Next week.
Next week is from 5th onwards.
My
All
9th.
right, we'll keep it on the 5th. It will stay on board for 5th. No need to show it. But who will appear for Munna then?
I think Mr. Kishore Mishra.
His name,
I will.
because his name has not appeared for that reason, perhaps he has missed the list.
Mr.
Kishore Kumar Mishra.
The name of Mr. Kishore Kumar Mishra be shown in the cause list,
Can I pray for 6th, my lord?
appearing for respondent number 1. Yeah.
Can I pray for 6th of
All right.
on
List on
Tuesday?
6th. All right.
Quick list item number 2.
This case was already earlier heard by Mr. S.K. Mishra, Honorable Justice S.K. Mishra and Mr. S. Dr. Myler, partner matter. That earlier I have submitted my written notes of argument and citation, my lord.
All right. You can show the same written notes to us. No difficulty.
And that the appellant punishable in the trial court offences under section 13(1)(e) of the Prevention of Corruption Act 1988, with section 8(3) of the Special Courts Act 90, has been sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of 5 lakhs and default of payment of fine, undergo rigorous imprisonment for the period of 18 months, my lord. That is the order of the Special Court. In paragraph 2, that on 24/3/90, PW 11, Honorary Naik, Inspector of Police, attached to Vigilance Director Cuttack, conducted in a house located at Aparna Nagar, Chalaganj, Cuttack, on the basis of such warrant, Exhibit 64, my lord. The appellant was residing with his family members in the.
Not item 2. This is Criminal Appeal 87 of 95. Bharat Chandra Rao. Why is it before a DB? Because it's special court case, is it?
Special court.
Oh.
Exhibit 64 is such warrant, my lord. The appellant was residing with his family members in the said house. The raiding party consisted of Judicial Oja, Executive Magistrate Cuttack, PW 20, Ramesh Chandra Mahanti, Deputy SP Vigilance, PW 17, and others. They were seized various articles as per seizure list, Exhibit 45, my lord. As per prosecution case, the valuation of different articles in Exhibit 45 were indicated on the basis of information given by the appellant, except the valuation of gold ornaments. That on the basis of the aforesaid search and materials available, the disproportionate asset of the appellant was worked out at the sum of rupees 5,20,610, and first information report Exhibit 46 was lodged before Special Vigilance City Cuttack. Accordingly, the case was registered. That after registration of the case, the investigation was entrusted to see Radhaman Patra, PW 26, Inspector of Police Vigilance Cuttack, who took up the investigation on 29/3/90. The valuation work of the building situated at Aparna Nagar, Chalaganj was undertaken from 11/6/90 to 13/6/90 by C. Rabindranath Mahanti, Assistant Engineer, PW 23, who was assisted by Ganthabera, Building SI Vigilance Director, PW 2, and 2 valuation report by Exhibit 89 and 90 were submitted to PW 26. After conclusion of investigation, after obtaining the sanction order by Exhibit 102, charge sheet submitted showing the disproportionate asset at the tune of 8,03,395 of 8 paise. During course of trial, it was considered by the prosecution that the income of some rupees 50,000 and CPF loan and 2,000 in respect of salary had not been taken into consideration. As such, the appellant was ultimately called upon to explain the disproportionate asset to the tune of 7,51,395 rupees. That in order to prove this case, prosecution examined 26 witnesses as well as on behalf of the defense, 23 witnesses were examined. All the details witness statement clearly indicates in my appeal petition from page number 5 to 10 that the learned trial judge, while appreciating the evidence on record, came to the following conclusions that some parts he has not accepted, my lord. I have indicated the advance of rupees 15,000 as claimed by the accused to have received by his wife, DW20, for sale of Saira land during the charge period is unacceptable in page number 32 and 33 of my judgment, my lord. That net income of salary of the accused rupees 3,57,114, that is page number 32 and 33 of judgment mentioned. That loan amount 20,000 as claimed by the accused to have received from DW7 for purchase a car given to the first daughter is not acceptable. That is judgment page number 36 and 37 of the judgment. The conclusion of the buildings at Upper Nanagar by late Jagannath Mahanta and transfer of the same to DW20 by virtue of Exhibit 50 is not acceptable. Exhibit 50 is not a genuine document, and the accused had spent money for construction of the two buildings entirely and not part only claimed. That is mentioned in judgment in 37 to 51, my lord. The claim of the accused that DW20 received 40,000 rupees towards her share after the death of late Jagannath Mahanta cannot be accepted, my lord, trial court. That is mentioned on 51 page, 52 and 82 of the judgment. The expenditure of the accused and his family members on food, clothing, light, footwear, etc. 2,35,000. The expenses on electricity charges is 6,501. The educational expenses rupees 23,482.56 paise. Expenses on stamp and registration charges 3,000 of 98 of 50 paise. That is mentioned in paragraph for 57 and 58 of the judgment. The marriage expense of the first daughter of the accused is 1,14,050, and that second daughter is 1 lakh. That is mentioned in page 58 to 68 of my judgment, trial court judgment. The joint account of the State Bank of Bikaner and Jaipur, standing in the name of Ramohari Raut and Swaswati Raut, does not relate to the accused, and the value there has been excluded. That is page number 63 and page 64 of the judgment. The plea of the accused that the television set and refrigerator found during raid belongs to Marathi Jana, mother-in-law of the accused, cannot be accepted. That is not accepted by the trial court. The plea of the accused that the scooter found at the time of raid belongs to Rabindranath Mishra, a friend of the son of the accused, cannot be accepted. The articles found during the raid at Hulda official residence, which are the official properties, to the tune of 4,470, has to be excluded, and as such expenses on household articles was taken at 68,530. That is mentioned page number 66 and 67 of the judgment. This has been provided by DW8, Rabindranath Mishra, not examined, my lord. That is the important one. The claim of the accused that part of the gold seized during the raid belonged to his daughter, DW19, and the balance of the gold were gifted to DW20 at the time of marriage cannot be accepted. That has also not be accepted by the trial court. The house rent receipt and counterparts do not merit any concession, and the claim of the accused to have been received 2,03,150 towards house rent cannot be also accepted. The house rent was taken 1,45,000. The trial court finding. The claim of the accused that he received an interest from bank and postal deposits rupees 9,560 is to be accepted. Page 82 and 83 of the judgment. The agricultural income, it is most important, my lord. The agricultural income from the Hanupur land standing on the name of DW20, wife of the accused, cannot be accepted. That is mentioned in paragraph 88 to 90 of this judgment. Prosecution has admitted in Exhibit 128 that in the share of the agricultural income of the accused from 1969 to 90 is 21,150, basing on the expenditure on food and clothing has been calculated by the prosecution in view of the consistent evidence on Bhag tenants DW3, 4, 5, and PW19, and surrender of interest by brothers DW16 and 23 in a joint family remaining at Delhi and Madras. The income of the accused during check period, that is 1962 to 90, from lands of Saira, Sangamanga, and Soilancho will be 1,11,520. This income should have been added to the income of Monrama from lands of Hanupur and Saira. So assessment of income by trial court is without any judgment on the basis, without any basis. The claim of the accused that he was enjoying the shares of the agricultural income of his brothers cannot be accepted. Page number 92 of the judgment is mentioned. The claim of the accused that there was piscicultural activities and plant trees in the area 46 decimals of land purchased by DW20, wife of the appellant, cannot be accepted. The accepted extent of the land of the accused in Mahuja, Saira, and Sangamanga is 91 decimal 5 codis. As such, another 5,000 is to be added in the agricultural income. Page 5. For the Soilancha lands, a sum of 2,000 is to be taken, and the same has to be added in the agricultural income. The stand of the accused that DW20 received a sum of 6,000 towards the sale price of the land situation in Aparnanagar is to be accepted. That the investigation officer PW26 was not authorized and to complete. That is not that the sanction. The seventh I have mentioned that some misconception, prejudice, and adverse remarks of the trial court. The trial court expressed grave doubts and suspicion on Exhibit 50 due to the following reasons. The cost of construction 5,000 up to ground level 2 feet below plinth level is ridiculously low. Mahanta corrected as Mahanti, last page 50. The caste of the purchaser has been shown as Karan, but Monrama accepted that she belongs to Khandayat caste. The accused stated he had invested rupees 56,607 is the building construction. The building is in finishing and completion stage because sanitary fillings were not fully completed. Exhibit 128 is the building plan. All the above noted points used against the accused are mere speculation, imaginary and unfounded, and non-application of mind by the trial court due to the following facts. Page 6, my lord. The facts is the cost of the construction up to ground level 2 feet below the plinth level given by the prosecution, Exhibit 30, is 5,312 as per 1974 schedule rates. So to 5,000 can never be ridiculously low figure in 1969. Mohanty has duly corrected by Mohanta and correction slip is in the cell deed. The Exhibit S. The accused nowhere stated to have invested 56,607. He has stated in accused statement that his wife has spent some money for minor construction out of the house rent.
This written submission you filed in 2010?
Yes, ma'am.
2010, 12 years ago.
No.
2020.
2020.
You've wrongly typed it as 2010.
2020. 20 minor. 28, 9, 20. 20.
It's typed here as 2010.
No, 20 minor. Yes.
So the appellant is 87 years.
Yes, ma'am. He's an old man of suffering, bedridden and.
So how many, during the pendency of the appeal, how many days did he spend in jail? Was he in judicial custody at any time?
No, my lord. It's not.
He got bail throughout?
Yes. In this regard, I have cited a Supreme Court decision, my lord, 2017 2 OLRSC 717, my lord. That is squarely applicable in my case.
Where is that? You've enclosed it?
Yes, yeah, I have been.
It's there, correct. Vasantra Guhe.
Yes, ma'am. It's squarely covered by my case. Some disappearing property has not been taken.
You're for the
My
state.
lord, the questions raised by my friend has been discussed clearly in the judgment, my lord. In fact, by giving some ads, the judgment has not left any space for adding anything more, my lord. That is, the judgment is very clear. He has discussed with point of law and as well as the facts, my lord, and reached a reasonable conclusion.
All right. We'll reserve orders and examine it.
My lord.
All right. So can we begin tomorrow on the next matter, Mr. Dala?
My lord.
We'll begin your matter tomorrow.
My lord, item number 3, my lord. This case was, I was engaged by Mr. Nanda when he was taken as additional government advocate. So, my lord, when I saw the list yesterday, I asked him, he said, client has taken the brief because hearing was closed in the month of September 2020. So, after the hearing was closed, my lord, it is but natural that I had returned the brief to Mr. Nanda. So, but the brief, he says the client has taken the brief because hearing was closed, judgment was reserved. So
normally clients don't take the brief without judgment having been delivered.
No, my lord may see the order sheet. The hearing was closed in the month of September 2020.
I know. But I'm saying till judgment is pronounced, no client takes away papers.
That is his client. My personal concerns are his clients. Well, so usually I keep the brief till the end, my lord. Some even 30 years back briefs are there also. But here I could know from him. My lord, if some time will be given, I will again, my lord, get the paper book. And
you just take a pen drive, you can get the entire paper book. It's all scanned, completely scanned.
Yes, my lord, it can be completely scanned.
1996 appeal.
My lord, I will do it. But I have argued the case. I know, but without brief, I cannot argue the case.
So you will permit you to just give us a pen drive. You can take it in the pen drive. You bring the pen drive.
My lord, 10 days time may be given so that I can prepare a short note also for that.
We'll stay on board. We'll call it in the week of 5th. It gives you sufficient times. There are many holidays now.
Yes, ma'am. 7th or 8th.
Let us see, because we are taking something on the 6th.
Yes, on 6th.
You take it to the paper.
I think then on 7th or 8th. So that day.
Yeah, it will stay on board. It will stay on board. All these will just stay on board.
Well,
all right.